Beautiful. Yes, please. Yes.
My lord, in the year 1986, a separate department of sports was created by the Andaman administration.
Right.
Subsequently, by 2004, my lord, funds were allocated and the posts were transferred. But at no point of time, recruitment rule was framed for appointment of the post so that regular appointment could be made in the said post. Now, my lord, some recruitment rule with regard to some posts, like director post is already recruitment rule was framed after a litigation by an incumbent before the court of law. Now, my lord, for other posts, recruitment rule was not made. Now the administration, because all along the officers of the Directorate of Education were sent and they were working under the sports department on deputation or whatever mode, my lord. Now, my lord, the very purpose of promulgating such a separate department to uplift the sports in this island was defeated, my lord. And now they are trying to amalgamate the Department of Sports with the Department of Education. And I can show from the document, my lord, the post was created in 1986. Posts were transferred in 2004. 2011, post of director was created.
Mr. Kumar, how can you say that they are trying to amalgamate?
Because, my lord, it's a specific meeting. Because, my lord, will find that all the officials
Are the same.
who are deputed there are from the education department.
Two questions first at the outset. One is that isn't it the prerogative of the administration to create posts? I mean, or departments even. I mean, it's there.
There is a department of sports, my lord.
They have created it.
1986.
So can't they amalgamate the two if they want? Can we? Yes, but can there not be a joint department? I mean, if can the court dictate them as to how to create their departments?
No, my lord. I say, my lord, when there is a separate department, posts were already transferred to the said department.
So at least till the department is there, there should be separate recruitment rules.
So the post also 2004, all the posts were transferred, my lord. Now
posts were transferred. What do you exactly mean by this? Posts were transferred.
Posts were created, my lord. Because the creation of the post is by the government of India.
So funds have been allocated, posts have been created, but no recruitment rules.
No recruitment. Director sports was created.
Only that after litigation. Okay.
Documents are part of my petition.
And how are you affected as a? I mean, you are a football association.
I'm interested in sports in this island.
Very well. So that is all. Let us hear them, and then we'll. Yes, yes, Mr. Kumar.
I am appearing for response number 3 to
both of you, Mrs. Kumar. Well, and Mr.
Yes, sir.
Administration Kumar.
Yeah. But they have seeking that a separate recruitment rule has to be framed and it should be treated as a separate department. But so far as from the
isn't it already a separate department?
No, it is. The initial it was that thereafter not all the staffs which are working under the sports and youth and affairs what belongs to the director of education. No, at no point of time.
Please explain this concept. All the staff were
working presently under the director of sports, youth and affairs.
They are acting under both departments.
Yes, my lord. They have been brought from the education. They have been transferred to the education department to the director of sports and youth affairs. Not. They are saying the amalgamation that has no process has been till towards that has been on record, not because I have an instruction that not because the post which is already the director of department it is not a separate department. The ministry has not conferred any approval for treating it to be as a separate department. So the staffs which are working under the director of education used to be worked before the director of sports, youth and affairs.
No, the ministry, which ministry has not permitted?
Probably it should be the ministry, response number 2, Melo.
Achha. Minister of Youth Affairs and Sport.
Yes.
But if there is a department, all the other departments have recruitment rules, right? So why should this department also have an independent set of rules? Because you have already created a separate department and funds have been allocated, posts have been created. So if funds are allocated and posts are created, then should it continue as a stopgap arrangement, or there should be a formal recruitment rules so that people can apply and get appointed there and whatever.
Due respect, Malad is right, because if there is a post who has been created and a separate, it should be. But not so far as I have instruction, not they have not done so at far with regard to this. It is required an affidavit subject to lordship permits, because
What will you disclose in the affidavit? Just indicate to
with
us.
regard to whether the post there was a separate entity in terms of lordship is pointing out whether there was an sanctioned post by the ministry, and based
So
on
one of your submissions is that the ministry has not created, no approval has been
not given any concurrence that it should be treated as a separate department.
File a short affidavit, Mr. Kumar. You are, when we have found you out on Monday to be very.
Report it can be not. I just
form of report you can also file it.
Let it fix on Wednesday, so that I can
Fair,
report.
fair. Sorry, just Melon. What is the notification? Sorry, creating a separate department?
My lord, that page 33, my lord.
That would stop the approach of voting direction. Separate department create. Separate department person. Separate department for they are just appointing the assistant director of a different department as lecturer, which is. Separate department with affairs and sport, Union Territory of London with immediate effect. With the following field officers for anything is organization. Mr. Vinukumar, if you kindly see page 33, then as my learned bench partner is rightly pointing out that it was first of all issued by the Assistant Secretary Education.
No, that is with the approval, my lord. Assistant Secretary cannot.
Well, of the appointment.
It's an administrator under Article 239, my lord.
Yes, but a separate setting up a separate department for youth affairs and sport.
My lord.
With a view to ensuring focused attention on youth programs for effective coordination and liaison with the youth programs in the territory. Lieutenant Governor has also been pleased to order that the Assistant Director of Education, who is at present looking after the youth and sports activities. So the Assistant Director of Education is already looking after the youth and sports activities as well.
Yes.
So it's taken within the umbrella of education. If that be so, there is no distinct entity.
Can we come to page 43 now?
It is as if it's a subordinate wing of the education department. Page 43, yes.
If my lord sees that setting up a separate department of youth affairs, that was the language used, my lord, in page 33. Now 43, my lord, we find. Consequently, allotment of disbursing the administration to Assistant Director, Sports, Arts and Culture was order dated so and so. The Director of Education under Director of Sports, Arts and Culture with effect from 1/10/2004. So from 1/10/2004, we have separate drawing and disbursement, and this post will transfer. And several posts will transfer. Can we see the Director of Education, my lord, at it is a page number 49.
Also, it says as a stopgap arrangement.
Yes.
You may have a point there also.
Yes.
Till the creation of new non-teaching posts in the Department of Sports.
Yes, that was created subsequently. That documents are also there.
Stopgap is. Sorry, which page?
49, my lord. It's the recruitment for the post of director. At page 51 is the schedule of the said post.
Now the stop for each one. If a department create rules, that posts should create rules.
There is no separate, there's no requirement for creating a director of sports. And there is a case before this honorable assistant director, and he was deputed from the department of education and subsequently absent. My lord, he saying that he stagnated the post and the requisition director I fulfilled. My lord, this court passed an order director on the basis of an order passed by this was framed, my lord.
We're directing affidavits. We're directing affidavits. We'll just note the initial points taken. The present public interest litigation has been filed by a football association in the Andaman and Nicobar Islands, pointing out that although a separate department for youth affairs and sports was created by the administrator of the islands, and pursuant to a previous court direction, recruitment rules have been framed for the post of director of the said department, no recruitment rules have been framed for the other posts, which have already been created and funds allocated for the running of the newly created department. First of next para, learned counsel appearing for the ANN administration submits that there is some doubt as to whether the concerned Ministry of the Union of India has granted approval for creation of a separate department for youth affairs and sports. Secondly, from the documents annexed to the public interest from the petition, it is sought to be pointed out that there is a thin line of distinction between the Directorate of Education and the newly created department. As such, it is submitted that there is no requirement under the law for enactment of new recruitment rules separately for the different posts of the youth affairs and sports department. Next para, be that as it may, since the ANN administration seeks to use an affidavit in opposition disclosing the germane facts and documents, we direct the respondents to file their affidavits in opposition within. Please file that within Monday or Tuesday, but they require some time to use a reply.
Relating to on Tuesday, not
Well, by April 21, 2026, reply, if any, shall be filed within how much?
A day or two, my lord.
2 days. Within Thursday, within April 23, 2026, let the matter be listed for hearing next on April 24, 2026.
The affidavit in opposition by way of a report.
Affidavit in opposition by way of a report.
Blair.
Yes.
My lord, I am appealing for the petitioner, my lord.
Yes.
In this matter, my lord, this petitioner was entangled in a criminal case for possessing illicit liquor, my lord. And as a consequence of which he was initially suspended, a criminal case was initiated and he was suspended, followed by a departmental proceeding wherein he was dismissed from service. Now, my lord, when he was dismissed from service, by that time, my lord, his appeal was pending, and for expeditious disposal of the appeal, my lord, he has filed an original application before the Central Administrative Tribunal.
Appeal against what?
Appeal against the order of dismissal, my lord. Now, in the meanwhile, the criminal case which was initiated against him ended in acquittal. Now, the said factum was informed by him to the court, and the court directed the authority to consider it in the light of the acquittal of the applicant. Now, my lord, despite of that, the appellate authority, without application of mine, my lord, affirmed the order.
Before the court direction was passed, he had already been dismissed.
He was dismissed, my lord. After
Yes,
yes, during the pendency of the appeal, he was acquitted from the criminal case. Now, my lord, challenging disciplinary authority and the appellate authority, he preferred an original application. Now, my lord, when the application was filed, firstly, my lord, the department failed to provide evidence the proceeding against him. Therefore, on merit, that order cannot sustain. Secondly, the punishment which was accorded to him is disproportionate. Since, well, for this offense, my lord, because he is working in the police department, similarly circumstances, other constable, they were given lesser punishment with some deduction in the improvement. So on these two fold, my lord, we have challenged it before the tribunal.
Other constables were co-accused in the same.
My lord, in different.
Similarly situated.
Similarly situated case under the section 32 of the 1876 Act, which says the punishment can be extended up 6 months and fine to the extent of maximum to the extent of 1,000.
No, the punishment does not incorporate dismissal at all. They can dismiss also.
No, but the judgments which were passed in others' case, my lord, it will clearly establish they were given punishment. So that punishment was disproportionate. This was the point which we have agitated.
Subsequently also incorporate this acquittal.
Acquittal. No, my lord, what happened? In the meanwhile, Supreme Court judgment came, my lord, that is of Ramlal, 2023 December, which says, my lord, if on identical allegation and on identical evidence, if a person is acquitted from a criminal case, then, my lord, the scope of judicial review of the court, in the scope of judicial review, the court can consider to ascertain as to whether after such acquittal, the departmental proceeding can be culminated into punishment or not. And the Supreme Court, in a case where it was an allegation under 467, 468, and the Supreme Court said the order that is acquitted from the charge, the Supreme Court said no, it cannot sustain and then set aside and directed to reinstate it.
Does the tribunal deal with these issues?
Tribunal has not dealt with this issue. Tribunal, argument, and I have given my written notes of argument also. Tribunal considered only my second part of said, my lord, that on the basis, because similar circumstances, persons were given lesser punishment, the tribunal directly dealt that part and directed that the answer point. First, the punishment cannot sustain in it. I can demonstrate from the document itself, from the gist, I can demonstrate. Secondly, my lord, once this is my submission in an earlier round of litigation in another case, that once there is a definite finding of the tribunal that cannot sustain and the tribunal has set aside the order, there is no point in doing before an administrative decision.
All the materials were before the tribunal.
The tribunal is finding that it cannot sustain. My contention was that when a judicial authority has arrived to a definite finding, the order cannot sustain, relegating the matter before an administrative authority arrives at a decision of the judgment.
Can you please see the yes, the order of the 253.
Tribunal's order is at 36, my lord.
Have made suggested agreement on that solution.
The order of the coordinate bench which ends at page 253.
My lord.
It was regarding the same person or different person? Similar.
Fact as well. I say, my lord, this was my specific case before the tribunal. Even the tribunal's application in ground I have specifically stated. See that there are two sets of witnesses, police witnesses, my lord. The episode taken place in a public say that most of the witnesses say that the seizure was affected from checking where the person was moving out of the vessel, my lord. And some of the witnesses say that the seizure was affected at police station. And witnesses. And some witnesses say it was not from his possession, but it was lying nearby his seat in the bus. And the trial court has not accepted this version, and the trial court has acquitted him from
Let
it.
us see the tribunal's order was, what is?
Tribunal's order, my lord. My lord, tribunal's order is at 36, my lord.
And let us come to the relevant findings.
My lord.
Clearly hold procedure. Clearly hold.
Para 6 onwards.
To the extent. Then clearly. So you are not contented with the remand, first of all.
Yes.
Secondly, you say no punishment should have been
Yes.
meted out.
Yes.
Because of the acquittal.
Yes. And because of the judgment of Ramlal and GM Tank, my lord, which clearly says that, my lord, if identical allegation, identical witnesses, then in that case, my acquittal in a criminal charge gives a right to the court to consider it in a review jurisdiction and to arrive to a finding whether it can sustain or not.
Can you cite Ramlal?
Yes, my lord. My lord, may kindly come to para 9, my lord. The issues which were framed by the court. Whether the dismissal of them was pursuant to the remand was justified on the fact of what is the effect of acquittal ordered by the appellate court in so and so, so and so. Para 11, my lord, we find that we have examined both the question independently. We are conscious of the fact that the writ court power to review of the order of the decision is very limited. The scope of inquiry is only to examine whether the decision-making process is legitimate. As part of the exercise, the court exercising power of judicial review are entitled to consider whether the finding disciplinary authority have ignored if it is so finds to interfere. Thereafter, my lord, paragraph number 30. However, charges in and the criminal are identical or similar, and if the evidence, witnesses, and circumstances are one and the same, then the matter acquires a different dimension. If the judicial conclude that total proceeding is after full consideration of the prosecution evidence and the prosecution miserably failed to prove the charge, the judicial can grant redress in certain circumstances. The court will be entitled to exercise discretion and grant relief. If it concludes that allowing the finding in the disciplinary proceeding to stand will be unjust, unfair, proceed. Now, my lord, may kindly see paragraph number 21 onwards, my lord.
The Supreme Court itself considers the evidence.
Yes.
Identity of.
Yes, my lord. Paragraph number 20, my lord, last part. Last line, my lord. It is well settled that if a finding of the disciplinary authority shall not interfere, it is only to satisfy ourselves to this extent that we have scrutinized the material to see as to what was reflected in the record. We are satisfied that the disciplinary proceeding are vitiated and deserve to be quashed. Thereafter, my lord, let me see paragraph number 20 proceeding. With this above background, if you examine the following factual position above, the very same witnesses who were examined in the departmental inquiry. Now, my lord, kindly come to paragraph number 25. It says, my lord, expression like benefit of doubt and attitude used in judgment are not to be understood as magic in computation. A court of law will not be carried away by the use of such terminology. In the present case, the appellant will thereafter kindly come to paragraph number 26. Because rest are the facts of that case, my lord. Para 26 says,
And language alternative on those.
Para 26 says, my lord, we are satisfied that the finding of the appellate judge in the criminal case clearly the charge against the appellant was not just not true. In fact, of the charge even stood disapproved by the prosecution evidence. As that this the fact is said to be disproved when after considering the matters before it considered its non-existence, so that the circumstance of a particular case to act upon the supposition that it does not exist. A fact is said to be not true when it is neither nor disproved. Seven. We are additionally satisfied in the teeth of the finding of the appellate judge that cannot be allowed to stand. The charge were not just similar but identical, and the evidence, witness, and circumstance were all the same. This is a case with an exercise of discretion. We call the order of the disciplinary authority.
So in judicial review, it has been held that yes, if the court the authority proceeded without any material or perversely, then it can.
It was identical, my lord.
No, that is the second level.
Yes.
That then there can be judicial acquittal if the prosecution in both the proceedings were identical, witnesses were same, then same.
It would have the same dimension, my lord. So to come.
So here, this shows the criminal court's findings was.
My lord.
Mr. Kumar, all the papers are here. We're hearing you.
7.
I should have said that at the outset.
No, it was served, my lord. It was served that.
I make my assumption.
It was served, my lord.
In these cases, point out at the outset,
Yes.
you'll hear it. There should be no. Yes, yes, Mr.
7, my lord. Hello, criminal case and the disciplinary proceeding arising out of the same fact.
Not this, just a second.
Judgments, so persons who were examining the proceeding also.
The witnesses were the same.
Police persons, my lord, all, most of them are police persons, and I have given the number also.
In the corresponding proceeding.
Yes.
So you have given the number of P 1, 2, and 3 PW. The rest were additional.
My lord, is the list in the departmental proceeding, my lord?
58.
58.
Acha, in the department.
Departmental proceeding, list of witnesses, my lord. Now, my lord, can you see page 88 once? I will just give the number. My lord, can you come to page 88 of the judgment? The list of the PW
Yes.
narrated. My lord, PW in the criminal case.
Edith and Satyavati we have seen.
Yes, Editan Satyavati and the assistant course. He is at serial number 6, my lord.
Acha.
And thereafter, my lord, he said serial number 9. Sure, is serial number 5. Thereafter, my lord, first James. He's not given, my lord.
Dixon Sampson.
This person, my lord. Dixon Sampson at serial number 4.
Yes.
Spelling is mistake, my lord. This person's their number and all is there, my lord.
Samuel is 1.
One.
Yes, 7 is 1, my lord.
Does it hinge on PW6 additionally?
PW6 Thomas James, my lord. That
Extra.
he was perhaps, no, I don't know. It's also a police person, it seems.
We'll just look into this judgment. We'll put elements. Page 92 তে বলছে in fact prosecution has failed to bring any iota of it. Oh, sorry. এই এসিটা একটু ঠান্ডা করে দিতে হবে। ইয়ে এসি থোড়া ঠান্ডা হোক।
গরম হচ্ছে
Ask me, believe in them.
ফুল স্পিড এবার দিও না কম হোক।
এখানটা চ্যালেঞ্জ আসছে দুটোই আসছে করতে পারে পেজ 92 তে না মাঝে মাঝে বলছে যে ইনফ্যাক্ট দ্য প্রসিকিউশন ইজ ফেইলড টু ব্রিং Independence witness नहीं शेयर होगा correct. Actually, independence witness. Actually, witness. Is there a witness? Independent witness evidence.
Access established.
You are making it part hard, Mr. Kumar. We're keeping it tomorrow.
And my lord, we find that it's what I have contended that Caesar is never proved because the so the also I have 92 saying that the Caesar has
You
not.
have seen intelligent.
One thing,
It's in the scissor list.
Yes.
No independent witness at the time of evidence also.
yes, and one thing is that time we see problem 5 para 9 that the discrepancy in the statement of the witnesses who and these witnesses that I have clearly narrated, my lord. How if my lord sees first paragraph number PW para and my lord.
Evidence have you annexed here somewhere?
Evidence is there, my lord. Evidence is there. Starts from page number 59 to 69, my lord.
Did not place that. You can place para 9 itself.
Yes, my lord, para 9, H, my lord. I'm sorry. PW 8. I'm just giving the contradictions, my lord. Para 6, it says the inspector so and so in his cross exam stated that the Caesar was affected in the presence of the public. Now, my lord, PW,
The one at the inception says was not carrying the seizure.
yes, yes. And now, one more thing, para N, which is contradictory. PW is stated in clause the Caesar was affected station Karnikumar. So, this witness, I could have understand if any independent witness comes and makes this statement, my lord. And the police authority, I have given said that there is no requirement. The contradiction, my lord, I have taken.
Several private persons.
Yes, it's a public place. It was a harbor where the vessel came and my lord.
May not be essential, they can available in there. And second paragraph I বলছে যে stated that there were private passengers traveling in the bus. Apart from that, in the bus itself there were other witnesses on a public place. So hard in part. Question on the prayer of learned counsel appearing for the respondents, the matter is adjourned till tomorrow for further hearing. Mr. Vinu Kumar, if you can please give a photocopy to Mr.
I have given the copy, sir, my lord.
So that you can get the portions highlighted by him also. You can argue, no, actually, it helps. It's an adversarial process only for the purpose of arguments, not between counsel. Yes. Achha, effectfully. Mr. Kumar, can you please just ask your clerk to, Mr. Vinu Kumar, can you please ask your clerk to just stitch it? The copies of the.
Yes, yes, yes.
You have marked it, so don't take it back. Just ask him to just.
Yes, my lord, I will do it.
One second, judge copy. পেন্সিল মার্ক যেটা আছে সেটা আমাকে দেবেন আর অন্যটা দিদিকে দেবেন তাহলে বুঝতে পারবো কথা মার্ক করেছে নেক্সট এই সরি এটা ওটা আছে এটা ফেরত দিন
ওটার সাথে
জাজমেন্টের পার্ট এটা ফেরত দিয়ে দিন ওনাকে
চলে গেল
রেখে দিন মিস্টার Yes, next.
As for the respond number one, not
Yes, sir.
WPCP.
Challenge the order passed by the honorable trial.
Yes.
Then appeal by the administration. But I like take lordship's kind attention towards the vacancy. Not at-
And please take the microphone a bit closer to you. You're already soft spoken and.
Got it. No, I just.
Now you can take your seat and.
No, I just give the brief facts of the case now. And vacancy notice was published for post of surveyor under the deputy commissioner office. While publishing the vacancy notice, it was specifically mentioned that 2 years diploma / certificate course will be entertained. Now, based on this, the recruitment rule also transfers the same essential qualification which is in the vacancy notice. It was advertised and the respondent herein, she also applied. She has been allowed to appear in the written examination. She has qualified in the written examination. She has found to be as a meritorious candidate under the OBC quota. A candidate at serial number 3, my lord. So after when it has been processed, the authorities come to know after verification of the document that she is having only 1 year certificate course. Subsequently, the final merit list, her name was not appeared. Agreed by that, she went to the tribunal. Now the tribunal has said that you have allowed her to be as a 1 year, you allowed her to be appearing in written examination. So you give her appointment by creating, if required, supernumerary post or the post is not filled out, then the other private respondent who are to be affected, they will be taken into consideration and a supernumerary post is good, they have been given appointment. Lord, my humble submission is, my lord, the vacancy notice which is published, it is at page number 101.
But there will be a cascading effect
Yes,
in the sense that other people could have come in her place. So then you have to.
Lord,
reinitiate
they
the process.
already they have been party to the proceedings.
They were parties to it.
Yes,
Anyway, page 101, let us see whether there is a scope of your relaxation.
yes, yes.
You place whatever is against you, I mean, in the vacancy notification, so that we can,
No, yes,
if there is some scope of relaxation or your discretion,
yes.
you
Lord,
understand our question?
yes, yes.
Right, yes.
Lord, may kindly come to page 101.
Yes.
Lord, this is essential. Right hand side, Lord, 1, 2, 3, 4.
Essential, yes, essential.
Essential, Lord.
Oh, that's essential.
School examination, 10th pass from a recognized board, 2 years diploma / certificate course in a surveying from any recognized industrial training institute, ITI. 1 year experience in the concerned line. So, Lord, I have upon Lordship's kind attention towards clause 2, 2 years diploma / certificate course in surveying from any recognized industrial training institute.
Yes.
My lord, page number 102. Instructions, my lord. The candidates applying for the post should ensure that conditions prescribed for the post of examination, admission of the candidates for online examination for the post notified in the notification of the information furnished by them in the online application. If any stage of the it is found that any information furnished by the candidate in the online is false, incorrect, or the candidate has suppressed any relevant information, or the change otherwise does not satisfy the eligibility criteria for the post, this candidature will be cancelled forthwith. No, the vacancy notice, it transpires that if at all, Milord, I admit, Milord, because she has allowed to be participate in the written examination. But subsequently, if it is found that she is not been eligible, then it is already advertised in the vacancy notice. It can be cancelled or forthwith. It can be treated to be as a forthwith because it can be have authorities have a right to cancel.
Well, let's see the tribunal, how the tribunal proceeds.
Yes, Milord. The tribunal order starts at page number 129, Milord.
You can start from para 8 if you may so, please.
Yes, Milord. It is noted that the notification therein against, I am reading para 8, Milord.
Yes, yes.
It is noted that in notification therein against column essential qualification, it was mentioned that 2 years diploma course certificate in surveying from a recognized industrial training institute. The respondent have sought for clarification from the industrial training institute Dolligan with respect to the recruitment of the post of surveyor in agriculture.
Give us half a second.
Milord?
এইগুলো আকাস্টিক কোশ্চেন পুরো এই ফালতু বসে একটা আকাস্টিক কোশ্চেন আর সব খুলে বেরিয়ে যাচ্ছে একটু একটু ভালো ইয়ে নতুন কিনে দিতে তবে ছোট ছোট যেগুলো হয়
Forever change.
দেখো তোমার সব খুলে বলছে Anyway, yes, please continue.
Lord, they have, the tribunal has quoted the letters from the principal for amendment in the recruitment rules with regard to the director of Panchayat, director of agriculture. And Lord, the operative part is page number 136, para 9, my lord. May I read, my lord?
Please, absolutely.
It is further noted that as per the respondent, since the applicant had completed 1 year certificate course and not 2 years diploma course, therefore she was not found suitable, though otherwise she was qualified in the written examination and was placed at serial number 5 in the overall merit and serial number 2 as an OBC candidate. Therefore, from the perusal of officer 2 clarificatory letters referred to the respondents in the year 2017, the prior to the notification dated 1/8/2000, it is evident the respondents were aware of 1 year certificate course before publishing of the vacancy notice. Even then, they had rejected a candidature applicant which is not valid. Therefore, the applicant is entitled to be appointed against her position in the merit list. It has been further noted that though the private respondent was served with a copy of the OA affidavit of service was filed, but private respondent has chosen not to appear before the court or make any submission thereon. Therefore, we are not other alternative but to direct the respondent authorities to extend appointment to the applicant in the vacant post if it is still lying vacant as per the appointment letter dated 28/5/2019, as only 11 out of 12 vacancies were filled up by the appointing eligible candidates as per the merit list in the said merit list. From the date the other candidates were appointed with notional consequential benefit without back wages, and if no vacancies available, one supernumerary post be created to accommodate the applicant. Well, the tribunal has come to this specific finding that she is having a 1 year.
Almost unstable. I mean,
Yes.
you have
But I make my humble submission, Roshik. The vacancy notice, no, what is published in the vacancy notice, as Roshik was also said that it should be followed strictly because it is in public domain. Once it has been published, everybody is aware of the content of the notice. It cannot.
otherwise people who have
Yes.
1 year, they would have
They
also.
will also come. But if at all, the candidates as aware that there should be an amendment should be taken up place because there are series of communication, the authorities is doing something wrong.
Before commencement, they should.
Before participants, she could have challenged the vacancy notice and obtained a stay. Well, once she aware that she is an 1 year ITA course, she cannot retreat back and say that, so I should be considered that.
After what formality was left after the success in the reading?
But thereafter this is a written examination, then thereafter
Interviews.
trade, then merit list has to be published.
So in the midst of that, you
Yes,
cancel.
when the final list, she has been found to be
Omitted.
not successful. Not the same similar who has been scrubbed up before this honorable court. Not the honorable division bench has passed an order.
আপনি করে লাভ নেই আমাদের দিন
Not, I will not trouble because the factual aspect in this case was not, they also qualified in the written examination for the post of draftsman grade 3. But at the trade test, they have been not allowed, saying that you are not having the essential qualification which is published. They have higher qualification than the advertised, because in advertisement it was given 2 years ITA certificate. But the applicants, those who are in the writ petition, was succeed in the writ petition, he was having a diploma. But the court has said once an advertisement is published, it is a sacrosanct, it has to be followed. So based on that principle, my lord, the court has dismissed the writ petition in the appeal.
Supernumerary post question does not arise in any event there was one vacancy
Yes,
more. So let us hear the other.
Lord, this is my humble submission.
Yes, Ms. Lam.
Lordship, actually, there was some issues with regard to the course in question. The recruitment rule, when it was enacted, because if we see the judgment which has been passed, which has been just shown by the other side, your Lordship will find that the 2 year certificate course specifically mentioned. Now, your Lordship may kindly come to the vacancy notice as well as the recruitment rule, how it is mentioned. Vacancy notice, page number 1.
Page 101 is the vacancy notice. And this has been mentioned as an essential qualification.
Yes, Your Lordship.
That goes against you, apparently.
Your Lordship, that's what I just wanted to clarify that thing.
Yes.
Just a minute, Your Lordship. Yes. Now, Your Lordship, this 2-year diploma / certificate course in seven. My contention is that whether this 2 years is applicable to 2-year certificate also.
So you say 2-year diploma cut off?
Yes. Why?
Certificate.
Why?
Confusion.
The reason is there. This certificate course, the authorities were aware that from time to time it was getting changed. Initially, sometimes it was for 2 years, sometime 1 year, sometime 2 years. I will show from the documents. And the higher authority has said that 2-year certificate course and 1-year certificate course is one and the same. That also I will show. So these things were taken into consideration, and that is the reason why this interpretation, Your Lordship knows that the interpretation, if we have to do some interpretation, it has to go in favor of the candidate concerned. Now, Your Lordship, one by one, the document I will show. Your Lordship, may kindly come to page number 57. First. There are 2 numberings, Your Lordship.
We'll follow the within circle that
Pen.
blue one. We don't know, that will be black in your.
Your Lordship.
The one which is not scored through, basically. The other 2 are scored through.
Yes.
You are following the unscored through
Yes, Your Lordship.
pagination.
Page number 57.
Yes. 57.
This is a reply by the authorities under the Right to Information Act. Now, Your Lordship, may kindly see serial number 2. It is also clarified whether 1-year and 2-year course both are equivalent or not. If not, the difference will be furnished. If yes, necessary certificates will be provided accordingly. Both 1-year and 2-year course certificates are issued National Trade Certificate by the National Council for Vocational Training are recognized by Government of India. From time to time, it was getting changed. The year that completed, in that year, only 1 course was there. 2 courses were not at all there. Then next page.
এটা মারাতে হবে ওটা একই কিন্তু অনেকদিন ধরে পড়ে আছে
কি আমার ঘরে আছে আমার
দিদি
চেম্বার
থেকে আনছে
আমার চেম্বারে
কাউকে পাঠিয়ে
আমার চেম্বার
Next one, sir.
প্লিজ
67, na?
Sorry, Ms. Nakpa, please.
Important. Kaho.
So this was in what, yes, surveyor, diploma course was surveyor,
Surveyor.
yes.
Yes. Now, Your Lordship, may kindly come to page number 62. With reference to notification published in Daily Telegram dated this regarding recruitment tool of various posts under your department, it is informed that Subcommittee of National Council for Vocational Training on Training Norms and Courses held on 2nd June 2014. Dates are very important, Your Lordship. Has been decided that the duration of surveyor trade under craftsman training scheme has been reduced from 2 years to 1 year. The copy of the syllabus is as follows. Further, it is stated that Government of India has published National Skill Qualification Framework notification in the Gazette of India on this. The National Skills Qualification Framework organizes qualifications according to a series of levels of knowledge, skills, and aptitude. These levels are defined in terms of learning outcomes which the learner must possess, regardless of whether they are acquired through formal, non-formal, or informal learning. As per the said Gazette notification, all the government organizations and public sector enterprises were required to define eligibility criteria for all positions in terms of NSQF levels by amending the recruitment rules. In this regard, the department requested all these things. Now, Your Lordship, my point is that there was no requirement to amend the recruitment rule because the 2-year was only with regard to diploma and not with regard to certificate course. Because that was changing from time to time. Now, Your Lordship, next page number. ये कौन सा पेज नंबर? Next. Just a minute. You actually may kindly come to page number 64. This is a letter which has been written by the Department of Labor to all the heads of department. This paragraph 2 may be seen. It is pertinent to mention here that candidates of both 1-year and 2-year duration course in surveyor training are issued national trade certificates under craftsman training by this, which are nationally and internationally recognized. Hence, the candidates possessing 1-year NTC in surveyor trade shall also be considered for the post of surveyor. The director of RD, PRI, then local bodies and then already been amended the recruitment rule for the same. So this is given by the labor commissioner to all the heads of the department. Now, your lordship, one more document is there.
This came after the 2018 the vacancy recruitment notice. After you.
So there, your lordship, that's what
And this is clarificated in nature also. It should be word back.
clarification was given because there were rules also, sometimes it was 2 years initially, then 2014 it was changed to 1 year, then year. So the persons who had qualified during that period, they did only 1 year certificate course. It was recognized. That's why, and then again, the higher authority have said that both 1 year and 2 years are one and the same. Now, your lordship, kindly come to page number. Oh, page number, just a minute, your lordship. ये तुम पढ़ के सुनाया ना। ये लॉर्डशिप पेज नंबर 63 वैकेंसी नोटिस का डेट पढ़ो। ये लॉर्डशिप पेज नंबर 63।
Yes.
The Industrial Training Institute has written the letter, your lordship, to the
Yes.
concerned. Now, your lordship, may kindly see the third paragraph. In the academic year 2015, the NCVT and DGT, Ministry of Skill Development and Entrepreneurship, Government of India, has reduced the period of training to 1 year. Since 2015 to 2017, the trainees undergone training in Surveyor under CTS throughout India was for a period of 1 year. Now, from the academic year of 2018 onwards, the training period again been reverted to 2 years by the NCVT. So from 15 to 17, everybody for 1 year only. There was no course of 2 years. And that is the reason why when the RTI was given to the person concerned, the reply was that both this is recognized by the Government of India. Now, my point is that how this 2 year has to be taken into consideration by the court of law. Now, your lordship, the difference I will show. Your lordship, may kindly, I think judgment come.
Because after the sentence.
Your lordship, judgment just shown that the other side will be seen. Judgment which has been shown.
Yes.
Now, your lordship, may kindly see the manner in which the course is mentioned.
In the judgment who had appeared for the appellants?
Yes.
In the,
I appear for the response, so
no, the appellants kindly see the name,
yes, appellant Mr. Vinu Kumar appeared. I for the
not Mr. Vinu Kumar.
yes,
So
sir.
your influence was probably, the gender influence was probably too. Yes. Anyway, which page?
Third page, your lordship, B. Third page, serial number B may be seen.
Yes, B.
Certificate course, it is mentioned always like that.
So no slash.
No slash.
Okay.
So interpretation has to be done considering the entire aspect. The recruitment tool, when it was framed, they had the knowledge that from time to time, the courses, the period of course is getting changed. So that is the reason why diploma / certificate course is mentioned. So certificate course can be of any year, provided that is recognized by the appropriate authority and institution. That is already there. So many letters, so many these things are there. And now we are at judicial review. These aspects, this the tribunal has considered this particular thing.
See the consideration of this aspect by the tribunal?
Yes, yes, your
Because
lordship.
the ratio apparently refers only that they have already accepted.
No, your lordship, it is written all letters are written.
It is evident. Oh, those letters are quoted also. And it says that it is evident that the respondents were aware of 1 year certificate course before publishing of the
Yes, that they have taken. The tribunal has taken correct manner. But my question is that it is for the point of interpretation. Now, when slash is there, how we are going to add this to the certificate also? Should not be done. And they have put all those letters, everything are there. So, your lordship, this is not a case where, your lordship, the candidate's appointment should be taken away just because of the interpretation which has been done by the authorities in a wrong way. And moreover, all the documents are there.
Reply.
Not one short reply. Lord, if at all, Lord, for this saying that the 1 year course, as they say, the advertisement is / 2 years diploma / certificate. If it is 1 year's course is equivalent to be 2 years, as it is advertisement is said, and the Senior Council is pointing on. There is no requirement for any amendment. No, there is no requirement for any amendment because letters which shares that. Milord, if Milord.
We understand what you are saying,
Yes,
that the suggestions of amendment show that it was not there.
There.
Very well. But what about the other limb of Ms. Nag's argument that
Yes, Milord.
even irrespective of the amendment, suppose if we constitute as it is, then the construction which, because you have already taken her and she has passed one of the grade. Now, all the interpretations, all the communications by the relevant departments all show that both are on similar footing, and before 2018 there was only 1 year course for a large chunk of period.
Yes.
So why shouldn't both be treated to be equivalent? And we are saying this because yes, there is a subtle scope of interpretation. We understand under normal circumstances, we probably would have interpreted 2 years to circumscribe both diploma as well as certificate, which should be the normal plain reading interpretation.
Yes.
But why shouldn't we interpret that provision purposively to incorporate the interpretation by the labor department itself?
No, as Lordship is saying is. Right,
we are at the second stage of challenge. So
right.
tribunal
Yes. My humble submission is that not if their stand was that the 1 year certificate course, it should be at par equivalent to the 2 years, because this does not say that the 2 year certificate course is required under the vacancy. That was their interpretation. Not the Labour Commissioner has said it should be treated as 1 year. As such, it was requested all the authorities to make an amendment in the recruitment rule.
Right.
My lord, the recruitment rule as on today, there is no changes. Based on the recruitment vacancy, and advertisement was done. And the advertisement is specifically mentioned. If at all, madam, it is treated to be equal. There is no question of requesting the authorities or making an authorities to make an amendment in the recruitment rule. By incorporating, it should be as a 1 year.
Then what about your lordship, from page number 80 to page number 84? You have given appointment to these candidates who are only 1 year in the past. Why did you give?
But this is with regard.
You reply.
Commissioner,
before the tribunal, you have given the reply that it has been given. Page number 82, page number 84, certificates also are announced. Certificate course holder.
But we don't have those vacancy notices. Pursuant to which.
Same. There is no difference between the recruitment.
Right. This is not a vacancy, it's a recruitment rule itself.
Yes,
Notice.
the recruitment rule is important. They have just whatever is written in the recruitment rule is exactly written in the vacancy notice also. So in the recruitment rule, it is 2 years diploma certificate course. And on this page number 80 to 84, 80 is the appointment letter and the certificates are there. 2 year course. And when I have mentioned about it, they have not derived.
The recruitment rules are not annexed anywhere.
Next.
Rules.
Yes,
with regard to instant selection post, it is annexed.
it is there.
No, recruitment notice is there.
No, it is enclosed.
The rule is there.
Page number 104.
I've seen that.
105 is the scheduled
Reply because clarify them.
post of surveyor, serial number 8, essential.
Share the point. Article 14 also comes in. And your interpretation, previous interpretation.
This is
not only Article 14.
This is the recruitment rule for post of surveyor in the establishment.
This has been copy pasted there.
The
Copy
vacancy
pasted.
notice and the same.
Yes, exactly the same.
My humble submission is because whether the essential qualification which is prescribed, the 1 year or the diploma at par equivalent with each other, it has to be decided by an expert authority. Because
But several communications have been annexed here.
by the Labour Commissioner, but he has said for amendment, whether this 1 year certificate course certificate should be at par equivalent to the 2 years diploma course, that has to be.
No, that is not required. 2 year
They have
diploma course. I never submitted in that.
That 2 year certificate, 1 year, as Lordship is saying that prior to 2018, there is only 1 year certificate. Or only a certificate course of ITI.
No, Mr. Kumar. Therefore, if the recruitment rules was same at that period also, so he could not have referred to 2 year certificate courses.
No.
The recruitment rules was the same when there was only 1 year certificate.
No, the recruitment rule says 2 year diploma and / certificate course.
It was that itself when there was only 1 year certificate course when you give appointment to the previous persons. So therefore, if the recruitment rules, we are going to the recruitment rules directly, forget the notice that it reproduces. So if the recruitment rules did not want to segregate, meant to include 2 year certificate course, then you could not have given appointment to 1 year course people. Secondly, more importantly, during the period when only 1 year certificate course was in vogue, the rules remained the same. So therefore, if 2 year certificate course was meant in the rules, that could not have remained the same during the period when there was a 1 year certificate and you gave appointment to 1 year certificate people. So therefore, the interpretation has to be in the light of the past conduct also of the respondents themselves.
Yes, sir.
So that is where you're
But
losing.
as they are pointing on page number 81 or 82, whether they have been appointed based on the 1 year certificate score, whether that recruitment rule confined to the same in nature, that has to be ascertained also.
No, recruitment rule is the same. You're
No, they are not the candidates who have been selected based on this instant vacancy, because in instant vacancy, the merit list, none of the persons who have a 1 year certificate.
We are not looking into the instant vacancy at all. We are looking into your recruitment
Recruitment
rules,
rule, my lord. Right.
which have been reproduced in your recruitment notice for this particular post.
Yes, ma'am. Yes,
So therefore, we are going by that only.
yes, madam. The contention of the respondent was that because the recruitment rule earlier also it was that same in manner and nature, but you have given appointment to the 1 year certificate course candidate also by treating to be at par equivalent to the diploma person. So this was their contention. Not so far as this
2018, the letter was written.
Balwan
Letter, which was
No,
written.
Ms. Nag, don't
Yes,
interrupt him. Yes.
yes, not so far as the page number 81 to the 83, whether they are the ITA holders, their certificate shows this is an ITA certificate, but whether they have been appointed based on this, the recruitment notice, which I have pointed out, Lordship, whether or they have been any amendment took place, that has to be ascertained, Lordship.
Why you have not filed it?
So far as this contention with regard to this person's appointment, it has not been transferred in the tribunal's order also.
But there is no case, I mean, is it your case that recruitment rules had undergone a change? Recruitment rules have
No,
been.
in other departments, it is undergone a change. But with regard to the Deputy Commissioner's office, the recruitment rule has not been amended.
Yes.
The Deputy Commissioner's vacancy notice, which is Lordship, I have pointed out the recruitment, it is not been
No,
amended.
the amendment directions came only in 2018.
Yes,
And,
sir.
and in
Yes,
context.
yes, yes, no, yes.
But these are of 2007.
No,
At that point of time,
this
recruitment rules
certificate
was the same.
7, but they based on this certificate.
Here, recruitment rules, let us see.
2011 they have said. Prior, same recruitment rule was there. That is the reason why they have not produced also before the Land Tribunal. Because my specific case was there. But these people were certificate holder of 1 year and they have been appointed.
But
So if the census recruitment is different, they could have produced it. Why they have not produced?
I
The reason of not producing is that
this person, those who are pointing out, if they are ITA holders and they have been based on the same vacant recruitment rule, they have been treated to be as a 2 year diploma because they have been appointed, then I will not make any.
The labor commissioner, it was the labor commissioner which was issuing these certificates. Or some other authority.
No, it is an call this ITA.
Yes, it is.
and again rely
Mentioned that the
Page?
44. Again, I am relying upon page number 44. I'm sorry. Can number it?
44
Just, I'm sorry.
or 64.
63. 63. This is the letter to the institute itself.
Yes, institute we are interested.
Yes.
There are certificate at each.
Institute itself is writing the third paragraph. In the academic year 2015, this had reduced the period of training of 1 year. Since 2015 to 17, the trainings undergone training in survey trade under CTS throughout India was for a period of 1 year. Not from academic year 2018 onward, the training period again.
Your notice is construed in the light of what you were saying. 2 year certificate is a mandate. Then there could not have been any notice on certificate at all. 2 year certificate was not existent for the immediately preceding 4 years. 3 years.
yes,
So there could not have been any notification. There would be no one who had a certificate course of 2 years. So therefore, we have to read in your light. So we are not. No, we are dismissing.
my humble submission is whether that 1 year ITA certificate course should be treated at par equivalent to the 2 year diploma. It has to be decided by an authority. If that being so, then
We are
right, because
but we are.
that is my humble submission.
Let counsel appearing for the petitioner stroke authorities contends that the learned tribunal erred in law and devotes the concerned recruitment notice dated July 30, 2018, in setting aside the decision of the appellant authorities to omit the name of the respondent number 3, comma, a candidate who participated pursuant to such recruitment notice, comma, even after the said candidate having turned out successful in the initial written examinations. So next para, learned counsel submits that the learned tribunal proceeded on the premise that since the respondents therein, within bracket present appellants, bracket close, were aware of the 1 year certificate course before publishing of vacancy notification, comma, even if they had rejected the candidature of the applicant, comma, the same was not valid. Push-up learned counsel places much stress on the language of the concerned recruitment notice dated July 30, 2018, where, comma, under the column essential educational qualification, essential within bracket educational qualification, bracket closed, comma, 2 year diploma stroke certificate course in surveying was one of such essential conditions for to cross the eligibility threshold to participate in the said recruitment process. For some next para, it is contended that after the private respondent number 3 was permitted to take the written examinations on a mistaken approach adopted by the appellant authorities, comma, it was detected subsequently that she had only a 1 year certificate and, comma, as such, comma, did not come within the ambit of the eligibility criteria. For sub next para, learned counsel further submits that it is always open to the authorities to rectify their error, comma, even if any, subsequently, and to cancel the candidature of a person who did not have the eligibility criterion. For some next para, in support of such contention, comma, learned counsel also relies on the first bullet hyphen point instructions and annexed to the recruitment notice, which provides that if at any stage of recruitment or thereafter, comma, it is found that any information furnished by the candidate in his online application is false stroke incorrect, or the candidate has suppressed any relevant information, or the candidate otherwise does not satisfy the eligibility criteria for the posts, his stroke her candidature will be cancelled forthwith. Full stop. Next para. While addressing the arguments of the respondent number 3 to the effect that the interpretation by the certificate issuing authority itself as well as the labor commissionerate clearly go on to show that a 1 year certificate is equivalent to a 2 year certificate course, and that the during the period immediately preceding the recruitment notice, comma, the 1 year certificate course was only available for the last 3 years, comma, learned counsel for the appellants argues that the said interpretation only referred to a proposed amendment to the recruitment notice stroke rules, comma, thereby indicating that in terms of the recruitment rules as they stood on the relevant date of the concerned recruitment notice, comma, the expression double inverted 2 year double inverted close qualified both diploma and certificate courses. Full stop. Otherwise, comma, it is submitted, comma, there would be no necessity to suggest any amendment to the rules. Full stop. Next para. With regard to the alleged other persons who were given appointment to the self-same post of surveyor previously, comma, it is argued that unless it is before the court as to what were the exact terms of the relevant recruitment rules and recruitment notice pertaining to the concerned departments, comma, it cannot be ascertained whether the same principles governing the present recruitment would also be applicable to those. Full stop. Next para, further, comma, it is argued that it is that in order to interpret whether a 1 year certificate and 1 year certificate course is equivalent to a 2 year certificate course in surveying, comma, the opinion of an expert committee is, or at least experts in the field, is required to be obtained. Push up next para, it is contended that the learned tribunal, comma, accordingly, comma, proceeded on an erroneous premise in overlooking the mandatory essential educational qualifications as stipulated in the concerned recruitment notice in setting aside the decision of the appellant authorities. To the next para, learned counsel appearing for the respondent number 3 stroke candidate, comma, on the other hand, comma, places reliance on several documents, comma, arguing that those were considered by the tribunal before coming to its conclusions. Pushed up by an information furnished by the public information officer of the Office of the Labour Commissioner, comma, Port Blair, dated March 8, 2019, comma, it was clarified that both 1 year and 2 year course certificates are issued CAPSE National Trade Certificate within bracket NTC by the National Council for Vocational Training bracket NCVT bracket closed are recognized by the Government of India. Pushed up, further placing reliance on communication by the principal of the Industrial Training Institute, comma, which issues such certificates, comma, dated October 11, 2017, comma, it is contended by learned counsel that in terms of the same, comma, the duration of the surveyor trade under craftsman training scheme had been reduced from 2 years to 1 year, and it was further observed therein that in terms of the concerned gazette notification, comma, all government organizations and public sector enterprises were required to define eligibility criteria for all positions in terms of NSQF levels by amending the recruitment rules. First up, it is argued that in terms of the said communication, comma, it was recognized that 1 year certificate courses and 2 year certificate courses issued for the purpose of surveyorship stood on similar footing. Push up, next para, again, comma, learned counsel relies on a communication dated January 24, 2019, issued by the Labour Commissioner to all the heads of departments, comma, from which it is evident that candidates possessing 1 year NTC in surveyor trade shall also be considered for the post of surveyor. Full stop. Next para. Thus, comma, learned counsel submits that the recruitment notice dated July 30, 2018 has to be construed in proper perspective by lending an interpretation which is in favor of the candidates and not of the authorities. Full stop. Proceeding from such perspective, comma, it is argued that the expression TWO, T capital only, within bracket numeral 2, bracket closed, year, diploma, D capital, stroke, C capital, certificate, C capital, course, in surveying, S capital, purota, quote unquote, should be construed to mean that there is a disjunction between the expressions single inverted diploma and single inverted certificate insofar as the criterion of 2 years is concerned, and the said time period only applies to diploma courses and not certificate courses, comma, which are dissociated by the use of the mark slash, double inverted slash. Full stop. Next para. It is further argued that for the self-same post, comma, during previous periods, comma, other candidates having 1 year certificate were appointed. Full stop. Thus, comma, on the premise of principles of equality as well, comma, the respondents, comma, it is argued, comma, ought to be consistent in their interpretation of the recruitment rules. Full stop. As such, comma, it is argued that the learned tribunal was justified in passing the impugned judgment. Full stop. Next para. Upon a careful consideration of the recruitment notice dated July 30, 2018, comma, we find that 2-year diploma stroke certificate course in surveying has been enumerated therein as an essential educational qualification. Full stop. Next para. There is no manner of doubt as well that in the following instructions, comma, the authorities were given the laxity of cancelling the candidature if subsequently it was found out that the candidate otherwise does not satisfy eligibility criteria or suppressed relevant information. Full stop. However, comma, the said recruitment notice cannot be read in isolation and has to be read in conjunction with the recruitment rules, comma, which have been body-lifted in the recruitment notice itself and are a part of the recruitment notice, comma, under Schedule Roman 3 thereof. Full stop. Next para. From entry 8 of the said recruitment rules within bracket Schedule Roman 3 bracket close, we find similar language being used as reproduced in the recruitment notice as essential educational qualification. Full stop. Next para. Read in conjunction with the same comma, we find that the recruitment rules have been interpreted by several heads of the department, comma, including the Director of Employment and Training, comma, the Office of the Labor Commissioner, and, comma, more importantly, comma, by the Industrial Training Institute itself, comma, which imparts the education in question as well as issues the certificates in respect thereof. Full stop. Next para. From the same, comma, dated October 11 stroke 12, comma, 2017, comma, annexed at page 62 of the writ petition, comma, we find that 2-year and 1-year certificate courses for surveyorship have been equated by the Industrial Training Institute itself. Full stop. Next para. It is evident from the suggestions of amendment made by the Industrial Training Institute on October 17, 2018, that 1 or 2 years NTC under Craftsman Training Scheme in Surveyor trade approved by National Council for Vocational Training from a recognized Industrial Training Institute has been interpreted to give equal opportunities to candidates possessing NTC of 1 year and 2 years period of training in surveyor trade. Full stop. We also find from the said document that since 2015 to 2017, within bracket 3 years, bracket closed, comma, which immediately preceded the vacancy notice in question dated July 30, 2018, comma, only the 1-year certificate course was prevailing. Full stop. Next para. If we interpret the recruitment notice in such perspective, comma, the condition of 2-year certificate course as an essential eligibility criteria would negate itself if interpreted in the perspective of the fact that only 1-year certificate courses were available for the period immediately preceding such recruitment notice. Full stop. If the said criterion is interpreted to mean that only 2-year certificate course holders in surveying were eligible, comma, then the fresh certificate holders for the immediately 3 preceding periods, comma, when only the 1-year course was available, comma, would all get eliminated, comma, thereby reducing the zone of consideration by effectively eliminating such fresh certificate holders, comma, which cannot be a feasible mode of interpretation of the recruitment notice. For some next para, that apart, comma, the recruitment rules, comma, which were at the genesis of the recruitment notice themselves have been interpreted by several departments by equating the 1-year certificate course along with the 2-year certificate course. Full stop. Next para. Even the ITI itself, which issued such certificates, equated the 1-year and the 2-year certificate courses. Full stop. Next para. Thus, in the event a crunch situation arises where we have to interpret the concerned essential educational qualification either in favor of the respondent authorities or the candidates, the interpretation, it is well settled, ought to go in favor of the candidates. Full stop. Next para. Even otherwise, since both, since the literal rule of interpretation, if applied, would negate the eligibility criterion itself, as only the one certificate course was available at the relevant period, we choose to purposively interpret the essential eligibility criterion of a diploma stroke certificate courses, by disjuncting the expressions single inverted diploma and single inverted certificate and holding that the 2-year period applied only to diploma courses, which has been disjuncted from certificate courses in surveying by the mark slash. Full stop. Next para. That even otherwise, since the learned tribunal, after careful consideration of all the documents which have been placed before us, came to one of the plausible conclusions possible on the materials before the tribunal, there would be no justification in this court, sitting in writ jurisdiction, substituting its own interpretations, even if possible, for that of the tribunal. Full stop. Accordingly, we do not find any illegality or irregularity in the impugned judgment of the learned tribunal. Full stop. Accordingly, WPCT 20 of 2026 is dismissed on contest, thereby affirming the judgment dated July 23, 2025, passed by the Central Administrative Tribunal, Kolkata bench, Kolkata, within brackets, circuit sitting at Port Blair, bracket closed. Full stop. There will be no orders to cause urgency.
इसमें रूलिंग्स चाहिए कल करेंगे.
That's it. We did not consider the judgment, Mr. Kumar, in the previous one. We'll introduce one paragraph. No, we should. We have cited. After paragraph, Stephen, please introduce one paragraph. Put it in bold letter. We'll put it somewhere inside.
Yes, yes.
Learned counsel for our reasoning portion. Learned counsel for the appellant authorities has also cited an unreported coordinate bench judgment in a cost title. Please give the cost title. Where under similar circumstances, a contrary view was taken by the coordinate bench, by upholding the decision of the authorities in insisting upon the essential qualification as per the rules and the advertisement being upheld. Full stop. Next para. However, as rightly pointed out by learned counsel appearing for the respondent number 3 stroke candidate, the essential educational qualification in the concerned rules was couched in a different language in the present one. Full stop. In the said notice, the criterion was within double inverted 02 numeral years certificate course double inverted close, thereby tying up tying up the certificate course specifically with the 2-year time period, as opposed to the present case. As such, the said judgment is not germane in the present consideration.
Right. Your Lordship, I will respond, just not today, Your Lordship, tomorrow I'll do it.
On the prayer of the private respondent,
Yes, Your Lordship, private
on
response.
the prayer of the private respondent, the matter stands adjourned for the day. Blair, thanks. Please give your names, both of you. Your name should be written, yes.
Nakaratama file.
5 to 7 together, to. Action call,
And for the respondents.
action call, board action. 5 to 7, 5-7. 5 to 7.
We are, this petitioner is a medical officer, my lord. She was appointed as a medical officer on the basis of a recruitment which was paid.
1 second, board that could দেখানো হচ্ছে 5 to 7 hyphen for scope নেই not possible. Yes, please continue.
5 and 7 may be taken together because there is a common judgment of the central tribunal.
And 6, what is 6?
6 is separate.
6 is also issue is same. One more issue is involved there.
Judgment is separate.
So 5 and 7, we add the issue later on. You will have to.
Issues are same, my lord.
Issues are
So they
same.
want regulation should be from retrospective.
Judgment is common in 5 and 7, and 6 is a different judgment, but the issues are same.
Say issues are.
You are for the,
UPSC, Mrs.
I am for respond number 2 UPS.
UPSC. Let us say the petitioners first here.
On the basis, in the year 1985,
Mr. Singh is a petitioner in other matter.
the two matters. 6 months. My lord, on the basis of a recruitment, notified recruitment rule, my lord, the selection process was initiated and I was appointed as a medical officer on 2nd of August 1989. Now, my lord, in terms of the said recruitment rule, UPSC was required. Therefore, my such appointment was on ad hoc basis for a specific period and the same was extended from time to time. And such appointment was in a scale of 10, my lord. Now, my lord, in the year 1997, another recruitment rule came into existence. Prior to that, my lord, UPSC came and they conducted an interview. All the interviews around 17 to 18, all did not succeed and that appointment continued. In
You also did not succeed.
no. In 1997, my lord, another recruitment rule was framed. This recruitment was superseded. And in terms of the said recruitment rule, written examination was made mandatory. Now, my lord, when vacancy notice was published, I also applied and subsequently we all found that written examination is not possible. And by that time, my lord, a judgment of the tribunal came, whereby similarly circumstances, other medical officers approached the tribunal directed regularization and their service was regularized. So we taken that plea, we filed an application for regularization before the tribunal. Now, regulated this original application on 23rd of August 2004, the tribunal allowed this application and said that at that point of time, the tribunal was not aware as to what was in terms of the old which are elevated. And therefore, the tribunal said, you consider this, you see to conduct an interview, point the incumbent against the vacant post, which are not available.
You were also one of the petitioners.
I was one of the petitioner.
So in principle, it was set aside, but subject to ascertaining the vacancies.
Yes. The tribunal allowed for regularization, but since it was not brought to the knowledge of the tribunal as to what vacancies available. So therefore, tribunal said, you conduct an interview and appoint in terms of the vacancy which were available prior to notification of that is 1997 rule. Now, this challenge before this honorable court, they succeeded. They succeeded before this court. The petitioner, this petitioner along with 17 others, he preferred a special petition before the Supreme Court. Before the Supreme Court, the UPSC came and said, no, we should to comply. And such undertaking, my lord, SLP was disposed. Now, after the disposal of the SLP, my lord, subsequently, the administration has written letter to the UPSC to conduct an interview process. So they have conducted an interview and they appointed 50 persons to this said post. The The applicant in serial number 6 and 7 were left out.
Left out any reason has been given.
Reason has been given. Because so
Contemplated also, reasoned order was not required.
there may be some reason.
Show some reasons, yes.
Said serial number. The second candidate was appointed in 1989, rest of them were appointed subsequently. Now, my contention was that my NCR was so,
No, let us get it clear. The ultimate position was that on that round of regulation. The tribunal sort of order was to allow your regulation subject to taking interview
yes,
and availability of vacancies.
no,
So then two riders were put in.
Yes.
There were two you had to cross.
Yes.
One was interview, but vacancy availability, and that's very objective. But interview is subjective somewhat. They may say that you did not qualify for in the interview because you previously also failed to succeed in the interview. That is the difficulty facing.
Hello.
That let us see that direction.
it was a personal talk, not an interview.
But let us see that language of
Yes.
the previous. Because this order is, as rightly pointed out by my learned sister judge, is that yes, Justice Dasya also pointed out that this order is in consonance with that.
My lord, may kindly
Let
come
us
to
see that.
Yes, my lord. Kindly, my lord, I will just the further fact I just narrate, my lord.
Yes.
What happened, my lord? Thereafter, I filed a representation before the authority
Oh.
saying that you have arbitrarily rejected my candidature without assigning any reason.
Rejected, you challenge.
And the court they rejected. They're saying that you did not stood on merit, therefore we are rejected. That order was challenged before the tribunal. In the meanwhile, my lord, subsequent recruitment process was initiated wherein I appeared and I was appointed from the year 2015 in a subsequent recruitment process. And while accepting my such appointment, I accepted the same without prejudice to my right to challenge the earlier proceeding. That is there, my lord.
So what will be the effect? You will get the benefits from previous period.
Yes, this is my prayer, man. Now, my lord, the tribunal has not decided on. The tribunal said, since already there was an act, therefore the principle of res judicata will come.
Not res judicata may not be a correct expression, but Mr. Kumar, the previous order, that was the last settled position.
Yes.
The order of the tribunal, the last order of the
Yes.
tribunal. So let us look at that.
Yes. Now, my lord, straight away, my lord, it starts from 119, order dated 23rd of August 2004. My lord, may straight away come to page 173, para 16. From 15 onwards, my lord.
170.
172, my lord. Para 15 onwards.
No, 73 to the approach.
172, my lord.
नहीं
This is a typed copy, my lord.
that is
Typed copy, my lord.
WPCT, which one?
WPCT. I'm sorry.
7.
7.
Rajendra Singh.
7.
54, my lord. 54, my lord.
Rajani Reed.
7.
54, WPCT 54.
54. 54. 173. 173 এটাতে নেই। এটাতে আছে। এটা দেখতে হবে।
गलत फाइल दे
তোমার সঙ্গে 173 আছে?
डॉक्टर सबीला बन
Sabina, not Rajini Devi.
नो नो
173 is not there in the other. Sabila Bangla. এটা আছে, এটা আছে। এনে দেবো। না, এটা 173 আবার আলাদা। সাবিলা বানুকে দাও। 173 of Sabila.
172 my lord para 15 onwards of the judgment
Yes.
yes my lord it says however there is a different aspect of matter we find that prior to promulgation of 1997 recruitment rule there were separate for the
Different aspect of the matter. Sorry.
well there is a different aspect of the matter we find that prior to promulgation of 1997 recruitment rule, there were separate recruitment rule.
এই তো উফ এরকম। Wow. Sorry, please continue.
Well,
No, you
Yes.
start from where you ended.
we found that prior to promulgation of 1997, there were separate recruitment rules for the junior medical officers for which post the present applicants were appointed. These rules were called Andaman Nicobar Administration Junior Medical Officer Recruitment Rule 1984, and a copy of which is available so and so. These rules were notified on 18th of October 1985. It appears that the cadre strength was 36 in 1985, and the recruitment was to be made by Departmental Promotion Committee, whose recommendation was to be USC. From the year 1997 recruitment rule, we do not find that this earlier recruitment rule for junior medical officers stood or superseded. There is no other document produced before us that these rules were repealed earlier. Andaman Nicobar Administration response have also not denied existence of these rules in their written reply. However, we know that in the 1997 rule were framed under Article 309 of the Constitution, whereas the earlier rules were made in terms of the executive power of the Lieutenant Governor. Therefore, the 1997 rules, being statutory in nature, will prevail. Now, para 16 onwards are relevant because the relied upon this. The position that emerges is that the applicants were all appointed as junior medical officers since designation medical officer during the currency of the 1984 rule on annual basis. Under the new recruitment rule, June 1997, there were 92 posts inclusive of 3 cadre, namely medical officer, senior medical officer, chief medical officer. In the 1984 recruitment rule, the method of recruitment was by direct recruitment, failing which by transfer and deputation, etc. Admittedly, all the applicants were recruited directly with necessary qualification prior to June 1997. From the appointment order, we find that all of them were appointed by the Lieutenant Governor, and ex post facto approval was sought from the ministry. It was mentioned that they were appointed against short-term vacancies. Short-term vacancy cannot continue indefinitely, especially for 5 to 10 years. Obviously, the only process to interference is that the applicants were either appointed or adjusted against a regular vacancy, and the respondent had also considered that some of the applicants were in fact holding such regular vacancy. In the year 1984 recruitment rule, there was no provision for examination to be conducted by the UPSC, and the selection was to be made by the DPC consisting of Chief Secretary, Secretary Health, and Director Health. And its recommendation was to be vetted by the UPSC. In case the recommendation was not vetted, then fresh meeting was to be held, presided over by the chairman and a member of the UPSC. In the conspectus of facts and circumstance, we are of the considered opinion that since the present applicants have been appointed prior to promulgation of 1997 rules, their cases would be considered in accordance with the provisions of the earlier recruitment rule of 1984 against vacancies available in the date of commencement of 1997 rules. We are of the vacancy position in June 1997. From the record, we find that 27 adult doctors were regulated in 1980 and 9 others in 1995. As per the 1997 rules, this regulates doctor inducted in the service in terms of the Rule 6. Apart from that, there is also provision for temporary addition or alternation to cadre. Therefore, the authorities have to access the vacancy position first as at the date of commencement of 1997 rule, and then consider the case of the applicant and other similarly situated doctor as suggested above. The left out vacancies and vacancies occurring subsequent have to be filled in terms of the 1997 rule from amongst the candidates who have already applied in terms of the impute advertisement, for which if necessary, the vacancy notified may be modified. In the result, we dispose of this application with a direction on the respondent to take steps as observed in para 16 and 17 above. Those of the applicants who will be declared successful be regularized and inducted into service. Thereafter, the process of selection already initiated in terms of the advertisement should be completed till the applicants are considered or vacancies are filled up by the regular. The unsuccessful applicant may be allowed to continue their
Action was to follow the 1984 recruitment rules in the light of the pre-1997 vacancies.
My lord.
Can we look at that vetting provision in the 84 rules? Do you have that?
Yes, my lord. 84. My lord, may
1984 recruitment rule.
my lord. 14, my lord.
Yes.
Yes. Yes.
We'll continue to follow sub 11 with the page numbers.
My lord.
That will be easier for.
Page 115, my lord. It starts from 114, my lord, 18th October 1985. And my lord, may kindly come to the last second line from the bottom. Note, my lord.
Yes,
DPC composition is there, Chief Secretary, Secretary Director.
right.
The proceeding of DPC relating to confirmation shall be sent to the UPSC for approval. If however, or not, see a fresh meeting of the departmental powers to be presided over by the chairman and the member of UPC shall be held.
Parameters of that confirmation have been given.
Yes, parameters of that confirmation.
No fresh interview.
Nothing is required, my lord.
All right.
Only the approval is required, my lord. But approval is not the- Sir, further meeting is to be considered. It is not that if approval is not given, then first DPC will be considered and candidature will be rejected. Now, my lord, the Supreme Court is 179 because
Yes.
Supreme Court order, my lord, they have said that we will comply, page 179.
Is there a doubt, Mr. Shivabalan or Mr. Kumar, that you said that you would comply with Supreme Court order? No doubt on that. It had to be in terms of this tribunal's order which
Okay.
has been placed.
In 179, this is what exactly they have said before the Supreme
They're
Court.
not denying also.
My lord.
Yes, yes. Clearly.
Now, my lord, after this order of the Supreme Court, the administration written a letter on 18th of February 2013, page 180 to the UPSC. Now, my lord, first two paragraphs are with that Supreme Court order, and then after third paragraph is relevant. On the date of, because that vacancy provision, my lord, that on the date of commencement of third paragraph, my lord,
Yes.
Andaman Nicobar Service will notified on so and so that the number of vacancies were 16, of which 4 reserved for ST candidate. Further, there were 18 candidates in the instant case, along which 3 are in the service of the administration, and the remaining 15 are general category.
You are general category.
General category. ST doctors who have been working in the Andaman Nicobar since 1997 and on in implementing the order of the Honorable following 15 general category, 3 ST doctor, all of them appointed prior to be considered. This is a recommendation by the administration, my lord. Now, my lord, see next page, my lord. The details are there. Here, when you see, my name appears at serial number 2. I was appointed on 2nd of August 1989. Rest.
Who are the others? One is Rajni Devi and then Parveen Kausar. They are also there. Parveen Kausar is there. Yes.
Sir's name is at serial number 3.
That you have found. Rajni Devi.
15, my lord. 15. So within that 15, coming help.
All of you are coming.
Yes. She was appointed in 1989, my lord, and she has served in Farfel Island. Now, my lord, can you see? Therefore, the remaining 3 medical officers working in the Andaman for a long time may be appointed against the 4 posts of medical officer created by order 16 to 1999. So, my lord, the authority, the Andaman administration says, since they were working for years together, and we have found that there were only 15 posts, 15 general candidates, we kindly accommodate that. So far as the 3 posts are concerned, we accommodate the same in terms of the 4 vacancies which arrived on 14th of February 1999. Thereafter, my lord, in view of that, considering the long extent by the award so-and-so, where the regular doctor hesitate to work, the reasons are also.
4 more created, then the 3 other category candidates, ST candidates would also be accommodated. They are already working there.
They are already working. So the reason has been assigned. One of the award doctor so-and-so has gone to, can you skip that paragraph? In view of the considering long service extended by the other doctors in the Andaman conveying the selection process as per the rule and 3 so-and-so and as per the rule is 3. 18. Now the issue is the
Vacancy could not be an issue. Vacancy could not be giving you.
This was administrator, my lord, this letter. No, my lord.
So administration is with you.
Yes, yes, in this matter.
Yes.
My lord will find.
But Mr. Surveyor is standing in the way.
Yes, my lord, he is standing.
So we'll take care of him. Yes.
No, my lord, page 1 is the letter
Hmm.
issued by the UPSC. Now, my lord, I will see, it was not an interview. It says, I am directed to inform you that the UPSC has decided to assess the suitability of regularization of service of so and so on the basis of biodata ACR for the last 5 years and by holding a personal talk on 6th and 7th of November at Blair with the eligible candidate and request to inform the date and time for personal talk. Now, this is what done by them.
Parameter. The problem lies in the rules. There is no parameter for the confirmation. No yardstick for the confirmation. There is a problem there also. Anyway, so they have held personal talks with you and with biodata.
After personal talk, my lord, this is the letter issued by the UPSC at page 184.
But no, this is, what is the decision?
Yes, my lord, 184.
Oh, sorry. Yes. One.
Page 184, my lord.
Yes.
They say that I am directed to refer to so and so on the mention and to say the selection committee meeting held on so and so at Port Blair assess the following 18 general duty medical officer for regularization of service on the basis of available CR biodata by holding personal talk with them. Now, my lord, name of all the candidates are there. Next page. It says on the basis of the recommendation of the selection committee, the commissioner approved the following officer in the order of merit for regularization for the post of general so and so on regular basis with effect from 11th of June 1997.
There are 15 names here.
15. My name is not there.
3 ST persons are also there.
Yes. So my name is not there. The officer recommended for regularization will be appointed after the appointing authority has satisfied itself about the one thing is there. The only the credibility and the merit of an incumbent that has been considered by the BPC. And it was only an approval. And it further says that if on one day approval is not granted, if Malad sees the recruitment alert at page 114, Malad will find that it says if one go it is not done by the BPC, then once again it can be done.
Fresh meeting.
Yes. So the recruitment rule framed under Article 309 itself gives the power to the authority that once, if it did not succeed,
The eligible, what is that word? If however,
my lord, 140
cases, some are not approved.
my lord, it is there. This was exactly reproduced in the judgment, my lord, at paragraph 16.
Achha. So you'll
I'm
go
just,
there.
I'm just. लिखा है ना Malad, kindly come to page 175, Malad, that has been reproduced by in paragraph number 16. If Malad sees, second line, in the 1984 recruitment rule, there was no provision for examination to be conducted by the
That
UPS.
has not been reproduced.
No, it is, and the selection has to be made by the consisting of chief secretary, secretary, and director. Its recommendation.
Last line.
Yes, my lord. Was to in case the recommendation was not, then a fresh meeting has to be held, decided over by the chairman and the member of the UPSC. So consider the recommendation given by DPC.
Oh, that is these. These are not approved.
Yes. That is missing there, my.
These are not approved. These meaning the proceedings
Proceedings.
which are sent for confirmation.
My lord, they will only get the recommendation which has been given.
They publish their own merit list and all.
Yes. No, my lord. So therefore, that this was beyond the scope of the recruitment rule, my lord, which is a statutory recruitment rule promulgated under.
But then according to you, Mr. Kumar, Mr. Vinugo, what would be the scope of their vetting? What would they consider?
They have to
As per the rules, what should they see?
they have to see the documents which are there, my lord, ACR, biodata.
Which they have seen, they have said we have seen. Plus the additional the personal talks, that is beyond the scope, you are saying.
Yes. And ACR, my ACR is outstanding. And I am senior. 89 onwards I am working.
Already.
Now, my lord.
Yes, what else?
Thereafter, my lord, I have made representation, they have not considered. And my lord, thereafter. High Court करनी ठीक है क्या इसका speaking out of the 220
Last position. Last. মানে বলে দিচ্ছে যে ওদের অ্যাপয়েন্টমেন্ট হয়ে
ये पहले देखो
মানে বলছে বাই ডাইরেক্ট ফুডিংস ট্রান্সফার এখানে যেটা বলছে ডিপার্টমেন্টাল প্রমোশন কমিটি ডিসাইড করবে মোড অফ রিক্রুটমেন্ট ইজ বাই দিস ওয়াজ বাই ডাইরেক্ট অর বাই প্রমোশন
direct to
direct or by promotion by direct recruitment in case of recruitment by deputation transfer ছেড়ে দেয়
the cat counter भाग मिल जाएगा पहले
the only subject to being vetted ad hoc করছে only because the ব্যক্তি vetting আছে ad hoc appointment এর নেচারটা কিন্তু জিজ্ঞেস করতে পারবো Mr. Kumar, whether this ad hoc appointment gives a vested right, that's a question following from us.
No, my lord, nomenclature, my lord, recently Supreme Court has several judgments which says that we should not see the nomenclature. We must see that for what purpose a person was engaged. I will cite all those judgments, my lord.
If necessary.
Yes, because here she was appointed in a post in a particular scale of pay. It is not a consolidated pay.
And the work you were doing was equivalent to a regular.
Self-recommended, the February say that they from island. It is the recommendation of
Administration is fully with you and for valid reasons also, we can understand that. Because you worked in far from places under the impression that you had been. But in the, please come to page 114. Let us see the appointment where it says that you will be appointed. Or that we have started seeing from the proceedings being sent to the
114, yes.
114 and 115.
My lord.
We have started from the note that the
Yes.
proceedings will be sent for confirmation.
Yes, yes, my lord.
So just what language has been used for recruitment rules, they shall come into force.
Method of recruitment, my lord.
Method of recruitment.
Let the LEC by direct or by promotion, by deputation or transfer and percentage or the vacancy.
And this is your reading, which number?
My lord, from the bottom, my lord, sees fifth part, my lord.
Yes.
By direct recruitment, my lord, the practically mode is that by direct recruitment. Failing which only the other recourse will be open.
Recruitment বলছে সব জায়গাতে রিক্রুটমেন্ট করছে ডাইরেক্ট রিক্রুটমেন্টের কথা বলছে অ্যাড হক এর কোনো এখানে অ্যাড হক কথাটা ইউজই করো না অ্যাড হক ওয়ার্ড ইজ নট ইউজড হিয়ার অলসো ইট ইজ রিক্রুটমেন্ট which is subject to that confirmation.
Yes. They could have appointed them, but my lord, since the confirmation is required, therefore they cannot appoint on regular, my lord. That's why, or they could have an
Of the department.
ex post facto approval could have been taken.
But confirmation word is used.
Yes.
Anyway, So what we're saying, Mr. Kumar,
Yes, my lord has rightly pointed out, the word is to confirm. So they can appoint, but it will not be confirmed unless and until it is vetted by the. So appointment could have been.
it's not ad hoc versus regular as such, but
Yes.
recruitment versus confirmation of the
Confirmation, yes.
All right, yes.
Now, my lord, in the year 2015, they carried a regular selection process in a post, my lord, where I was appointed on regular basis. Now, my lord, while reporting it, my lord, page 202, I have accepted the same without prejudice to my right, my lord. So this was not an issue that I just want to place before my lord.
No, that may had been an issue. I mean,
No,
could
no,
have been
yes, it's 202. Definitely, it's an issue.
could have been an issue if it was not without prejudice.
Yes. This is with reference to
with-
so where I have
With original,
202, my lord.
yes. With had been, someone wrote with, yes, very.
Without, my lord, out is written in small, without prejudice to my right and contention, my lord.
Thank God she saw it. Or someone saw it. I mean. Yes, very.
Now, my lord, the speaking order of the UPSC, my lord, which was challenged, page 229.
There was another round of litigation where they were directed to pass a speaking order.
I made a
On that.
That was not considered. I went to cat and cat person.
Right.
Now, if my lord comes to page 230, because they have narrated in fact last paragraph. Whereas the exercise of assessment of this 18 ad hoc medical officer for their regularization was taken up by the commission by holding a selection committee meeting. Personal talk which was held on so-and-so, Dr. Shabila, who belongs to unreserved category, had also appeared before the so-and-so and was considered along with 17 ad hoc. Dr. Shabila and two others, ad hoc medical officer, were not recommended for regularization as sufficiently high position in the order of merit the vacancy. The committee recommended so-and-so. So, well, this file is contrary to the recruitment rule. They don't have the authority to apply to such finding.
Parallel with the recruitment process, which
Regularization of the ad hoc service. Therefore, DB considering the performance of the subscriber for the related. In this regard, the agents of the staff of the last. In the other data services, the lecture of the filing the images and subsequent.
এটা তো রেজিস্ট্রেশন বলছি
Opposition PSC. Page number
Opposition page 3.
मैं UPSC का नीचे देखो ये है
ইউপিএসসি কে জানাচ্ছি তো কনফার্মেশন দেন এরা অ্যাডমিনিস্ট্রেশন ছেড়ে দিয়েছে বলছে আমরা ভ্যাকেন্সি আছে
54 दो पेज
ভ্যাকেন্সি আছে তোমরা ওয়েট করো সাবজেক্ট টু 1984 84 বলছে নিয়ারলি বলছে কনফার্মেশন হবে কনফার্মেশন না করলে পরের একটা মিটিং করবে কারেন্ট কিছু করবে ভ্যাকেন্সি রয়েছে কিন্তু শুধু কনফার্মেশন অপেক্ষা সেখানে আঁকার একটা প্যারালাল বা ইন্টারভিউ নিয়ে মানে সেটা রিগাইড করা হবে রিক্রুটমেন্ট নিউজটা মেইনলি কনফার্মেশন আই হ্যাভ টু কনফার্ম প্যারামিটার্স নেই মানুষ ক্রিয়েট করি হয়তো একটা ফার্দার রিক্রুটমেন্ট প্রসেস প্যারালাল করে দিল মেরিট লিস্ট সাথে ইয়ে করে আর 2 নম্বর হচ্ছে যদি ধরো দুটো পোস্ট থাকতো তাহলে মেরিট পরিমাণ বুঝলাম এরা হচ্ছে সবচেয়ে সুটেবল সেখানে মেরিটটা কম এক্ষেত্রে ডিসিশন অর্ডারেও বলছে যে আমরা মেরিট লিস্ট পেয়েছি ওটা ধরে বলছি কিন্তু এই ইউনিয়নের তো মেরিট লিস্টের ব্যাপার নেই 15টা তো সিট না 18টা সিট পেয়েছে মেরিট লিস্টে প্রায় হ্যাঁ and there were 80 seats available so 15 for general candidates so there was no necessity for this merit list also we could have understood if there was this is for you also Mr. You will have to answer that
no they say that 12 general candidate was available
oh
for ST.
For that they have done it
Yes, and there was a recommendation of the administration saying that in June 1999 4 posts are lying vacant. they can be accommodated. And my lord,
Where is that? You placed that, but which
yes,
page?
that I have placed, my lord, that is at page 180.
100. So when this decision was taken, those were also there.
Yes. Last paragraph, my lord.
118.
80, my lord, 180.
Right.
Last paragraph, my lord.
So at that point of time, 15 were available.
Yes.
General category.
Yes. Because yes, that point of time available. Now, my lord, administration, even in the year 2024, page 188, once again requested, page 30th of December, sorry, 2014, my lord. 15 also there was a recommendation. Administration time to time has recommended, my lord. 184. So about 15 maybe. It is 16th February. 34th February.
So then there was no scope of, there was no scope of this merit list publication as such.
Yes. Time to time administration has recommended, madam. Even after their appointment also. This 15% and after the appointment of 15%, administration has recommended kindly consider the candidature of these 3 persons. They are working from 1989.
All right.
Now, my lord, this was the impugned order. Now, my lord, tribunal, all in the order has considered all the submissions advanced by me, even the judgments. I have relied all the more or less all the judgments of the Supreme Court, my lord, with regard to regularization and all. My lord, everything was considered, but lastly, the tribunal held that page 281, para 8.8. The applicants has relied on the recent judgments of the Honorable Supreme Court in support of their claim for regularization. On adopting this judgment, the Supreme Court has laid down the law that a contractual, casual, ad hoc employee engaged by the government should be regularized. However, as discussed about the claim of the regulation has already been adjudicated. If suppose, my lord, judiciary has passed an order, administrative order has been passed, whether negative my claim, whether I can be remedial.
Implementation of that basically.
Yes.
You are now seeking implementation of that previous order.
Yes, previous order.
You are not seeking a re-adjudication.
No, not at all, my lord.
Favor.
Yes.
You are wanting implementation.
Implementation of the order. And they have exceeded the jurisdiction. When the recruitment rule says something else.
Ground is apparently it was a wrong way to proceed with it because it is not a reopening of the issue you are wanting. Rather, you are seeking an implementation of the
order. I say that in terms
but on merits also we'll hear the UPSC as to what they have to say.
My lord, my prayer also in my prayer also I have said so, my lord.
Implementation.
No, I say, my lord, that vacancy which they have said from 1999 onwards, that to accommodate me in that, because the administration all along said this is the vacancy you accommodate.
Right.
And my lord, UPSC has said the same thing in their opposition, my lord. I will just place that also. 253, my lord.
In principle, there is no difficulty in implementing that order.
Yes.
UPSC not saying that we won't implement that order. But while doing so, they put out this merit list on the basis of the personal talks held with you. And they say, as per the merit list, the first 12 have been accommodated. But that was probably also on the premise that there was only 12 vacancies. Apparently, there was a mistake somewhere there. Because at page 231, if you see the second paragraph, Mr. Kumar, and Mr. Singh also, because we will hear you also. The available vacancies prior to promulgation got filled up with the recommendation 15, thus filled up with 15. So the premise of the UPSC was apparently that there were 15 only, pre-97. Now, one question will be raised by UPSC that all these vacancies being created and all, those are post 1997 rules. So pre 1997 is a yardstick on which you have to proceed.
Yes, yes,
Pre 1997, the administration subsequently said further posts have become vacant and all.
yes,
But they have to consider pre 1997.
Yes,
And
yes.
pre 1997, there were only 15,
yes,
out of which, I mean, 3 were ST.
ST.
So why should we fault them? Because this is subject to, let us go back to pre 1997. 15 vacancies.
Well-
We cannot take into consideration the subsequent ones. So even if the reasoning of the tribunal was wrong, it's not prejudicate in that sense. But we find that some modality had to be adopted by the UPSC also to do justice. If there are 12 vacancies, so they to put out a merit list on the basis of their assessment, and they say the first 12 will come in. Confirmed.
But my lord will.
So there will be 12 vacancies for general category. What can they do?
Yes, my lord. The issue is that, my lord, whether in terms of the said recruitment rule, they enjoy any power to go for merit, because my lord,
One step ahead to help out the candidates who are eligible. I mean, they could have just said that I confirm only whichever 12 look good, or confirm my state, or for example, females or males or whatever. They could have done it arbitrarily, but they gave some reason. We find for a change that the UPSC has gone on a footing of, I mean, natural justice in a sense, because they have assessed the merits and they say the first 12 I am confirming. They need not have gone so far. They could have just said, because the direction says we boil down to the previous direction of that way. That way says vacancy read in conjunction with confirmation. If there is vacancy, confirm. Pre-99 said. There are only 15. There are only 12 for general category. What can they do?
my lord, DPC was conducted, they assess them on the basis of merit.
But
Now-
what else could they have done? Because there are only 12 vacancies and they have to confirm some.
My lord, they could have on the basis of the seniority, they could have done. If my lord sees on merit, I was appointed in the year 1989. A person who was appointed in the year 91, 92 on merit
The
subsequently.
defect lies, Mr. Kumar, in the previous rules, as well as in that when the direction was passed, probably the intention was very good. But this was not taken into consideration as to what they would have to do if there are less vacancies.
But my lord, may kindly see whether they can travel beyond the scope of the recruitment rule.
If they said according to seniority I'm granting, that would also be traveling beyond. They have to
My lord, this is in the recruitment rule rightly pointed out by my lord, their duty was confined to confirmation.
very well.
Confirm the DPC, my lord. Things are there, my lord. DPC was conducted, DPC arrived to a definite finding, these are the
No,
persons.
there are 15, there are 12 posts. There are 15 candidates.
My lord.
So who would they confirm? That choice comes in.
My lord, DPC was conducted at different point of time at the time of our initial appointment. No further DPC was conducted. My DPC was conducted in the year 1989. Their DPC was conducted in the year 1991. Whenever we appointed, because on the basis of a DPC only, all the incumbents were appointed at different point of time. The consent was that, my lord, once DPC has recommended, thereafter for the purpose of confirmation, it has to be sent to the UPSC. And since that confirmation was not made, we approached the court saying that kindly regularize our service. The court said it will be done in confirmation by the UPSC. No,
They can only vet. They can only confirm. As per the rules, they can only confirm.
confirm, my lord. If on the process of confirmation, we cannot hold a new DPC where they assess the biodata or the ACR of an incumbent, because DPC at different point of when these incumbents were appointed, that was held.
Now let us come back to that OA, which is the genesis of all this.
Yes.
Please come back to page 174
My lord,
and 170 up to 176.
my lord,
So this is the broad contour within which they have to function,
My
the UPSC.
my lord.
Now 174 at near the end of it, short-term vacancy, about 6 lines from the bottom.
Yes,
Short-term vacancy cannot continue. This is the reason.
my lord,
So let us come to the next page,
My lord.
because the tribunal says as per 16 and 17.
my lord.
Even 16 is the reasoning. 17 is the main governing, the
Yes.
governing.
Yes,
17 says in the conspectus of a we are of the concept that since the present applicants have been appointed prior to the promulgation of their cases would be considered. It starts here. their cases would be considered in accordance with the provision of
Yes.
the earlier recruitment rules. So their
So-
cases would be considered
Yes.
in terms of the earlier recruitment rules. And then it says 18 also comes in. We are not aware of the vacancy.
Yes.
So vacancy was considered. Therefore, the authority has to assess the vacancy position first as on the date of commencement 1977,
Yes.
and then to consider the case of the applicants and others similarly situated doctors as suggested.
Yes.
Left out vacancies, forget that. So the 19 is somewhat vague in the sense that in the result we dispose of them with the direction to take steps as observed in 16 and 17. So those of the applicants who will be declared successful be regularized. So this declared successful comes in. Declared successful comes in.
My lord, declare successful will
Success means there is a competition.
has to be read with class 17 last two line. The court says in accordance with the provisions of the earlier recruitment rule. The provision of the recruitment rule says only confirmation.
But then court ties it up with the vacancy situation also, which has to be done.
My lord.
Vacancy taken cutoff date is pre-1997.
My lord.
Now, considering that vacancy in terms of the vacancy, two very serious terms have been used here. One is that para 17 itself.
My lord.
One is that their cases would be considered in accordance with the provision of the recruitment rules.
Yes, my lord.
So cases would be considered, we are leaving that. But then the crucial phrase is para 19.
My lord.
Those of the applicants who will be declared successful be regularized and inducted into service. So what can be the meaning of this declared successful?
But my lord,
An assessment, Mr.
my
Kumar.
lord, whether
Declared to be stated here according to seniority, then
my lord, the conjoined reading, my lord, can you appreciate the situation?
successful cannot
Yes, my lord.
refer to seniority.
Absolutely not, my lord.
You must be successful in taking birth first
My lord.
or attaining it first probably.
My lord, if a conjoined reading of the recruitment rule with this, my lord, they cannot travel. Court has passed an order, but the authorities cannot travel beyond the scope of the recruitment rule, my lord. Recruitment
They have to
rules-
confirm, but an
Confirm.
element of child's choice comes in. Number is 18, 15. The vacancy is 12. So what do they do? They have to choose the successful candidates and they will be regularized.
But we say that more reason has been assigned because my PCR was good. Now,
They categorically say that as per that you have done. Seniority cannot be a criterion here. You should have been representing them at that point of time. When successful would not matter,
yes,
seniority would have mattered.
two things are there. From this, if my lord sees, apart from this petitioner was working from 1989 to 2015. My lord, in post which is regular, because approval is not granted. My lord, whether this can be considered in the light of the judgments of the Supreme Court says that if a person discharge a perennial nature of duties in a permanent establishment for years together, under such circumstances, whether the post is there or not, it is absolutely irrelevant.
We cannot reopen that now because of the, you are also relying on the figure, last order, last position is no. That will hit the principle of res judicata. If you want, yes.
On page 157, come to the Jyoti's case. 147.
Paragraph 343. Indian res judicata. Please come to page 147, Mr. Kumar, para 3.1 of the judgment.
What is this? My lord, 146.
147, para 3.1 of the judgment of the tribunal in 2011.
Yes,
The last, it is pointed out, the last three lines.
yes, my lord.
Please start
The
from
applicant
there.
number 1234, Jyoti Sabila Kishore and Kausar PSC had afforded interview before the UPSC for appointment to the post of
Written.
so and so held on so and so at Port.
No, this argument was advanced by you, Mr. Kumar, no, not this person. না previously যেটা আপনি বলছেন সেটা কেমনি পড়েন আবার তারপর তো রেটিং না রেস জুডিকেটা বলছি So did you take this point before the tribunal that you should be regularized as
Yes.
per the judgment?
I have-
Where is that point?
Yes, I have taken, my lord.
Let us see from this.
Regularization, my lord.
Yes, they should be.
Yes, yes, in the, because on the set score only I have relied all the judgments, my lord.
Experience certificate. Now, where is the argument dealt? Let us
Yes,
see.
yes, my lord.
Probably in that context, it was held to be residual. That you cannot now reopen that aspect of the matter. Constructive residual. In your case, destructive residual.
That's not the point.
Challenging the amendment 15.
He is relying on the previous judgment. How can?
He is admitting that position of the persons who are appointed in 15. In the prior position, he is admitting that position. He says, I should be treated at par with that 15, which cannot be done because there is a vacancy of 12. And that cannot be done. As such, the
Yes,
subsequent.
the first premise of Mr. Kumar's argument was on the basis of post 1997 vacancies. That we cannot take into consideration.
That is
But the employer, my lord.
That also on that aspect also residual. Are you relying on the previous judgment which is residual? You cannot reopen the vacancy position.
My lord, the employer is the best person, my lord, and they have recommended that.
Usually useful. It's a
We were servants. Regulation is not this part.
Yes, para 4.3, this says it's a prerogative of the commission to lay down the method to be followed for selection.
My lord.
Maybe that is they are going a bit too far on that. But some modality has to be evolved.
My lord,
If you have to fit these 15 people into the post pre 1997 vacancy, 3 have to go out. Which 3? Now for that no modality or regulation and all, that is not applicable here because of your rights were crystallized in the previous judgment of the tribunal.
My lord, page 288.6, my lord, this is the reason assigned by the tribunal, my lord, 8.6 onwards. Page 280.
18. Waiting.
280,
No.
my lord. The judgment of the tribunal.
No.
Second volume.
Para 8.6 onwards, my lord. Thank you.
Sir, 8 point?
8.6.
Because we do volume 35.
Acha. And my lord, the RR do not provide for regularization as a mode of recruitment. That was done all along in the instant case.
Para 8.5 summarizes it, Mr.
Yes, my lord. Yes. 8.5.
Summarizes what we are telling also. That available vacancies is GR category being 12 and the total number of remaining being 15. It is obvious that 3 of these candidates would not get the benefit of regularization. Respondents have followed the tribunal's order in letter and spirit, and the applicants have lodged their appointment terms, so you cannot revive the said claim. You cannot revive the claim by making, these new arguments. Limitation was already crystallized. How additional ground? This regularization question cannot be raised by you now. You have to go on the basis of whatever was there. You are not going into the question of regulation and what should be the criterion for that. They had to choose a mode and they have selected the best 12 according to their assessment. Yes, you are right. They have carved out something which is not there in the RR rules specifically. But when we have to carve out, I mean, nothing to all, better than that, something to some.
Yes, sir.
That principle was followed in the first order itself of the tribunal, to which all of you considered. Now you cannot reopen that chapter by saying that I have an additional right because ad hoc, because of this, my length of service. That is an additional right you're getting. You considered to that by saying that yes, I am agreeable to this. Whatever was the vacancy post there, they'll give the recommendation on the basis of that. New regulation will, you have a right of regulation, you cannot argue as a matter of, I mean, doctrine. Because that chapter cannot be reopened. You did not take up that point at that point of time. So you are barred by constructive res judicata also. But yes, what should be the modality to be followed by them? We think the best modality has been followed by them. They choose the best 12 according to their.
But my lord, I say, my lord, so far as ACR and all concerned, my lord, I have exceptional. So that they have not said in their opposition also, because it is a specific allegation made by us. But that has been not been dealt with. My lord, that apart.
They proceeded only on the basis of the interview, which should not have been. But they say somewhere that we have also looked into the, but they have not given sufficient weightage to those things.
No reasoning has been assigned. They simply said that on the basis of merit we have done it. But my lord, when you have decided to choose a person who is much junior to me, then definitely some reason ought to have been given that this is this is. When I specifically say that because my employers, all the documents are with my employer that I have an exceptional ACR.
This is the eternal dispute of seniority come merit, or merit come seniority everywhere, in our appointments also.
No, my lord, may I say this, my lord, because
Yes.
the administration all along recommended, my lord. Now they are the employer, if they want regularization and
There aren't so many posts, even if they want.
no, my lord, sorry.
Rightly, but the last recommendation was bad, contrary to the tribunal's order.
That's right.
We could not take into account the post 1997 vacancies. They are trying to do good to you. We appreciate that. We really appreciate that because you people will be in a peculiar position. Other way,
My lord.
anything will be left up in a
Now,
sorry
my
situation.
appointment is from 20.
You are still better because you've subsequently got an appointment. We don't know about Mr. Singh's client.
No, they also.
My
lord. After more than 25 years of discharge.
You're now fighting for that the previous benefits.
Means, my lord, that service we get, my lord, at least we will get the pensionary benefit and all. Only for nationally also.
Mr. Kumar, do you want to add, Mr. Singh, do you want to add anything to Mr. Kumar? Add that.
Yes.
We'll go to Mr. Shevam and add Mr.
For a moment, can you have my writ application? Rajni Devi.
हम बता देंगे.
Rajni Devi.
Just one number बता दें.
Page number 18 February 2030.
No, my lord, in my page 180, man. I will
That
just
will be easier for us.
Yes.
So just, Mr. Kumar, you just help Mr. Singh, help us rather to collate the pages.
Yes, yes, man. 180, man.
180.
This is a letter dated 18th of February 2030.
No, not that.
180.
180. Okay.
Every time you are making a sense.
क्या विनीता क्या हुआ सीजीएम में
Yes.
Now, according to them, on 11/7/1990,
नेक्स्ट वीक में रखो अरे मानस को बोल दो ना बाद में जगह नहीं बोल के डेट नहीं
bill return is being for STK. Bill for the general candidate and 3 for the last paragraph. And page
करो
39.
180 चार देखती है
16, out of which 4 were reserved for ST.
Bill for unreserved. General candidate.
Further, there were 18 candidates in the instant. No. Mr. Singh, please come to the last paragraph, first sentence. On date of commencement of 97 rules, notified on such and such. The total number of vacancies were 16, out of which 4 were reserved for ST. So there were 16 minus 4, 12 vacancies for general. Then they go on further, go beyond that previous order. Further, there were 18 candidates in the instant case, no longer in service.
And 3 STK. As per their requirements.
Hmm. Hmm.
Now, I was appointed for a duly constituted deputy, decided over by the king, and given as a point. When I was appointed at that point of time, there were 10 vacancies, 9 for the ST, 9 for the SC, and 1 for the SN.
That point of time cannot be taken, Mr. Singh, because you have also considered, all of you have considered to that last order, which says.
Is correct one or incorrect? My contention is they have not before calculated the vacancies properly. This was my contention.
Was this point taken before the tribunal?
Yes, my player was there. I haven't quit my player.
What is that?
In my application specific,
Acha.
I have placed
No, in your application before whom?
for the time, but
You are Rajni Devi?
yes, sir.
Oh, sorry. Rajni.
Page 9 of my application.
Ah. 6.
Got it, my lord?
In the process of getting. There are
Thank you,
three, so we are confusing between. It is 7th allow. There are 54. দেখছি গোড়া থেকে 54 7th তলায় আছে কিনা দেখছি দেখ। ভীষণ পড়ে পড়েছে, নড়ে না। আরে নড়াচড়া করুন একটু, দেখুন 7 আছে কিনা এখন। দুটো 7 ওদিকে দিয়ে দিয়েছেন। না সেটাও তো না, 7 আর একটা ও দুটো 7 তো ওদিকে দিয়ে দিয়েছেন আপনি।
Page number 49 and 50, my lord. It starts from page 49.
সবই যদি এরকম কাজ হয়। হ্যাঁ সে পেয়ে দুজন পেয়ে। থ্যাংক ইউ। Yes.
First prayer is to set aside the order which they have passed, rejecting my representation. Second prayer is an order be issued directing the respondent authorities to antedate her appointment on regular basis with effect from 11/6/1997 after completion of the exercise in terms of the prayer A.
11/6 is the date of the that 97 regulation.
97. What was the exact vacancy prior to the commencement of 97 recruitment rules? According
You
to
have just paid for antedating your appointment on that.
second prayer, and
First prayer is
directing the respondent authority to reassign the vacancies prior to the AN health service.
reasserting the vacancies.
Reassessment. Why I have said so? Because this, my documents are before the tribunal. Now, just for a moment, my lord, kindly come to the page. (136) of my application. This is a voting side of the file.
Page
136. Now, third paragraph, my lord.
What is this, Mr. Singh? What is this? This is a continuation of what?
File noting, my lord.
Fine.
It starts from 133. I'm referring to page 133.
Right.
The post results for the SC candidates for lying vacant over a period of 4 years. The Ministry of Finance has certified that the post reserved for the SC/ST candidates can be exempted from the purview of the ban orders issued by the Government of India Ministry of Finance OM dated 3/5/93 for maintaining the reserve quota posts, taking into account the field general category vacancies. 9 posts reserved for SC candidates are available for appointment to SC and ST candidates. Now, 9 posts were available. Now, the next phase, my lord, they have issued an advertisement. I have annexed a copy of the advertisement also. they have issued an advertisement from the second paragraph. They say according to these posts were notified in the Daily Telegram dated 1st August 1995 in response to the vacancy notice. 7 candidates had applied for the posts. These 7 candidates' names are there. Now, page 141. Selection committee held on 5/9/95 at 3 p.m. in the chamber of the Chief Secretary, Andaman Nicobar Admission, Port Blair, for the selection of suitable candidates for the appointment to the post of the medical officers in the scale of such and such on ad hoc basis. Now they were having, they have selected 7 candidates, and 7 candidates were appointed. There are 6 candidates were appointed. Total 7 candidates has applied. एक नहीं आया था, and 6 candidates have been appointed as it appears from page 142. Now these 6 candidates, out of these 6 candidates, except for one, Patrick Felicius, he is a ST candidate. All other are general candidates. Now the general candidates have been appointed against the SC vacancies. Total vacancies were 9.
These documents were annexed to an OA.
Yes, my lord, this is part of my OA. There were total 9 vacancies. Out of 9 vacancies, 4 SC vacancies have been given to the general category, and one SC has been given to the ST. This is the situation. Thereafterwards, knowing fully well, kindly just for a moment come to the page 137. Knowing fully well, that this honorable court has passed an order in CO number 30 within bracket W of 1992, an order against the appointment of SC candidates in any post in Andaman Nicobar Islands, against which SLP was pending. SLP was dismissed. Order of the Honorable High Court was upheld because there is no notification in under Article 341 of the Constitution by the President of the India for appointing. There is no SC category in Andaman Nicobar Islands.
No?
No SC category.
No, ST is there.
ST is there.
These are ST categories.
These are SC candidates.
ST.
SC candidates.
Yes, 3 ST.
No, so that is 97. Right?
That's right.
97.
So no SC, yes, very.
At that point of time,
Will be there. SC will be general for the purpose of this. Yes.
now out of 10, 6 have been appointed, 4 vacancies are left. On
Can we enter
99.
into this fact-finding calculation going beyond what the administration has said?
No, I'm coming.
We were wondering that also.
No, I will not take into the deep calculations, just for a moment.
No, can we? We are willing to go if necessary. I mean, but whether at this stage we can go into this. So you basically challenge this disclosure of the administration.
Those are the case.
And in your OA also you said that the assessment was necessary.
And at the same time, I have made a prayer in case if it is not there, not prepared. You consider my case for regulation from the further in respect of the 4 vacancies which were created by an order dated 16/2/99.
That probably we cannot permit you in view of you also having conceded to the previous.
I'm coming to that point. I know. Now, the question is, I was appointed on ad hoc basis. I continued on ad hoc basis. On the date, the 4 vacancies were created subsequently. Whether I was in service at that moment, whether I will get a preferential treatment or not, in respect of these 4 vacancies. Simply because the vacancies were not available in 97. Let us presume, for argument's sake.
Can we reopen that?
Hani?
Can we reopen that at this stage? After all of you having conceded to the last order up to the Supreme Court it went. And it was settled, the law was settled that whatever order was passed by the learned tribunal at that point of time, that you will go by that.
Why?
Nobody challenged that, reopened that Supreme Court order, no review petition. So ultimate position is that 11th of June to 1997 when the rules came into force, The vacancy on that date would what they have to go by.
But in that order also,
You can't rule that.
nowhere it has been said that all those candidates prior to that, those who were 15 candidates, that was a one homogeneous group. Out of these 15 candidates, if someone is not appointed because of the lack of vacancies, they will be appointed by open selection.
We don't understand. Please repeat.
No,
Provided that
15 candidates were
Yes.
homogeneous group,
homogeneous group, yes.
appointed prior to 97. Right?
Yes.
The town itself has said their case is to be considered as per the 1984 recruitment rules. Now, out of these 15 candidates, 12 candidates could not be appointed for the reason that there was no vacancy available. Vacancy available was 12 plus 4. One vacancy was still left, ST candidate is left here. Right? Now, from 16 to 1999, 4 vacancies were created. I was working on that, continuously working against that post, these 3 candidates. Now, can't we get the preferential treatment in respect of these 4 vacancies? Here in this case, I am relying back upon the Constitution Bench judgment in direct engineering services case. This is old paragraph 44. I can provide that.
You have it today, no? You have it today. The copy.
I'm going on to this.
लेके गया था
Which paragraph, Mr. Singh?
Page 28.
Yes.
Following aim. I read the aim. You sum up we quote. Once an incumbent is appointed to a post according to the rule, the seniority has to be counted from the date of his appointment and not according to the date of. Here I am not asking for the seniority. I am simply asking that my service, past service can not be wiped out simply on the grounds that their vacancies were not available in 1997 or 11 on the date of commencement of the recruitment rules. On that ground, can my service be wiped out? That is only one. And as far as the UPSC is concerned, conduct of the UPSC I will demonstrate from my detail.
Now, this says once an incumbent is appointed to a post, according to rule, his seniority has to be counted from the date of his appointment, not according to the date of his confirmation. Yes, we agree with that. So you get seniority as per counted from the date of appointment. Suppose let us proceed on that premise. We are proceeding on that premise. So your seniority is counted from that date. But this chapter was reopened by the order up to the Supreme Court, which went the tribunal order, that it is subject to confirmation. They will abide by the tribunal. Tribunal order then attains finality.
Those who are not appointed in terms of the vacancies which were available.
Including you are a party there, yes.
They will be allowed to continue till the UPSC nominee joins. It means we have got no right. My question is, Even after the.
No, they were directed to, the UPSC was directed to vet it, confirm it. Now, till then, whatever, but then that has to be done in the context of the 11th June 1997 vacancies.
Yeah.
In terms of that, in terms of the rules, taking into account the vacancies, they have to do it. Now, can we carve out new rights which were not argued at that? You could have argued at that point of time that I have a prior right. No prior right was given to any of the 15 candidates inter se.
Even just for a moment, come to the page 100. One more show. The recruitment section of the Union Public Service has issued a list of the conditions.
The one once in our OPEC. This is one, yes. No, why should we be sorry? We should be, I mean, yes, 117. Yes.
My name appears as serial number 2. Marks secured by me is 986. Roll mark, marks is 72. In the open competition, Parveen Kothia, 68.
All
Samira Manu is in the subsequent.
But out of these 15 persons, all of you have been appointed at different points of time.
Different points.
So we cannot have a comparative merit list of these, all these 15. So we are appointed simultaneously, we could have considered it.
What time? UPSC has published this. Now there are four what happened.
No, the yardsticks became different. You might have come second in your time.
This is in 2015, my lord.
It's provisional.
When I was not selected in terms of level 6.
Provisional.
Provisional. Candidature is provisional.
That's the point.
But that does not have anything to do with this matter at all.
Now, they wrote a letter again on 31st of December to the Secretary Health and Demanding for it. It starts at page 108.
So saying this is on a different footing altogether. How can this be German for our case?
Yes.
You are relying on all of you are relying on the last position which stood crystallized in the tribunal's order. The tribunal order which says rules of 1984 will be followed according to the vacancy position on 11th June 1997 rules when it came into.
This I am submitting because.
But post facto, whatever happened, how can I look into that? And they've got an appointment post facto.
Thereafter, what happened? 31st of December, they have written a letter. They have attached the document, which is at page 120. What are the marks penalty? Have you looked at 120?
That is in a different examination.
For the same examination, the first time my marks are 72. In the second examination.
So this is of 2015. You took another examination.
Same.
What same?
Fresh appointment, 2015.
Fresh appointment. How is this German at all?
No. Fresh, I attended in 2015.
Yes.
I was awarded 72 marks.
Maybe.
Subsequently, they wrote a letter to the Secretary Health, and there they informed that my marks are 70.
This is a different cause of action altogether.
No,
What does this has to do with?
only
Okay,
for the information of course. That
Maybe you might have done brilliantly in one day in
No.
2015, but you might have been dull in another, which happens to us all the time. Dull in one judgment, intelligent in another judgment. So that is taken care of by the appellate courts. The same principle also applies to the appellate courts, even then. But therefore,
my only humble
we
submission.
cannot look into something post.
No, all right, my lord. My only
It's just on your
no.
capability, your candidate's capability.
My
They will be
only
very capable. We are not saying all of these are medical persons, doctors. So all of them are qualified, competent people. We are not doubting that. But they have to proceed on some premise.
their case is recommended by the Andaman Nicobar administration that the remaining 3 doctors should be appointed against the 4 vacancies. Because they have rendered the service, precious service for the.
Andaman and Nicobar administration cannot go back on what they submitted, what is the last position crystallized up to the Supreme Court. That no, they will have to go by that. 2 yardsticks only. 1 yardstick, 1984 rules have to be complied with. Second is pre-1997 rule vacancy position has to be considered.
Even if I am selected in 2015, by
Even whatever happens,
competition.
subsequently you have been an opportunity also, been appointed also maybe.
No, I have been appointed from 2016.
Yes.
Whether my past service can go, can be
That
washed
is
out.
a different cause of action altogether. We are not considering that at all, Mr. Singh. That was not before the tribunal. You are only on that previous appointment, your initial appointment, which was in the subsequent, that's a different cause of action. We cannot enter into we won't enter into the merits of that. That will prejudice you otherwise. But what benefits were entitled to? Your only substantial contention is that Andaman and Nicobar Islands administration, this vacancy position as of 1997, pre-1997 rules, this is wrong. But you had to substantiate that by some positive thing.
Because
Did you prefer a challenge to this? Writ petition was the first challenge to this.
the first one.
But here you have not writ petition. OA.
Wait, in the OA I have mentioned.
You have questioned there.
I have a next number of the, in 2001, how many vacancies were advertised?
It is always in a state of flux, Mr. Singh. Every day it may change. Literally not every day. But vacancy position always changes. Every month if you see the vacancy position will be different. That
Whether-
can be a consideration.
Whether my lord, suddenly the ST vacancies can go up to 8. In 2001,
No,
they
we
had,
cannot proceed on conjecture, Mr. Singh. Either way, not in your favor, not against you. But we'll ask the Andaman, the UPSC rather, and the Andaman Nicobar Island on the vacancies, what they have to say on the vacancies, whether that vacancy position was right, and UPSC as to they have to justify the yardstick they have applied.
Alright.
And then we'll hear you in reply on this. Just saying, we are making it very clear we are not reopening 2015 things.
Madam. I'll leave.
Just Andaman administration
Madam.
on the vacancy position. Mr. Singh and Mr. Kumar, you can. Yes. Petitioner Mr. Kumar and Mr. Singh, please take your seats. Yes.
But I will not repeat what this page 117, that para 19, because as lordship has already gone through. I just take the last part, Lord. What are the vacancies available that are still filled into the
Cannot be reopened. We cannot go behind that or
And
forward.
the persons who have not been given regularization, they should be allowed to continue till the recruitment has been.
Which has been done.
So that has been settled position. But based on this, it went to Supreme Court, the UPSC has withdrawn, so we have written a letter to the UPSC, that is at 18th February 2013, my lord has read, we have and disclosed the vacancy position. But at that point in time, the vacancy position has not been challenged either by any of the parties. They admitted the position of vacancy position and it has been categorically held.
The first opportunity Mr. Singh's client had was the OA. Where else could they challenge that position?
But they could have been, could we say that the vacancy position which is indicated, my lord, for sake of argument, it should be said that the administration wrongly indicated the vacancy
And
position.
this recommendation of itself has not been challenged
Yes,
as such
yes.
a way.
They have admitted, but subsequently in order to have a, because the 3 persons have been left out. So as such, the administration has recommended they should be considered on the vacancies or the recruitment rule which is published in 1999. As such, not the UPSC, not based on their consent, they given their willingness.
They.
Give the willingness, not they have waived the right. Lord, may kindly come to
Which was that?
page number 194. Lord, prior to that, 192 is a letter by the UPSC. But there is a Sabina Banu in.
Yes, we have gone back. They're gone back. সব আছে সাজানো একদম ছোঁবেলা মনে করে রাখেন। এটারই 192 Yes, willingness. You asked for their willingness.
Yes, my lord, it is at page number 194. Certify that I am interested in participating in the above mentioned
Yes.
recruitment process for which I already submitted application in 2001 and expressed my willingness in 2006. Not all of them, all of 3 has given their willingness. Based on their willingness, the UPSC has considered their candidature and subsequently they have been given an appointment. It is not without prejudice, not a single line is written, my lord, that we are without prejudice or against our rights, it has been done.
Now,
But subsequently, if they say that they vacancy position, this, that, and all, the appointment order, they given in my lord, 199. My lord, the appointment order is at page 196.
Hmm.
Offer, I'm sorry, my lord, it is offer of
No,
appointment.
this is offer.
Offer of
Yeah,
appointment,
obviously it is.
which consists the terms and conditions.
This
With
is
the race.
the subsequent appointment.
Yes, yes, my lord.
Let us know.
It says that, my lord, it should be from 10 August 2016, my lord, 198. And they admit the terms and conditions.
No, no, this page 191 and 192, does it relate
No,
to that?
196, my lord. 196, that is 11 July 2016, the offer of appointment to the post of medical officer.
No, but this is regarding the subsequent question.
Subsequent, but these 3 persons who have been granted the appointment.
No, no, you relied on 190,
The 192 was in letter which is given and 194 is the offer of appointment.
no, this is, wait,
No, this is offer, no, they have given the willingness to participate in the selection process.
one second, one second, one second. No, here, 192 refer to that SLP.
Yes, yes, yes. No.
Specifically refer to
Specifically
that.
refer to SLP. They say that because the 3 persons are left out, so they ought to have been given then consideration.
Although
because
this is
already
subsequent
yes,
exercise.
subsequently. So the administration also recommended that they should be considered based on the 99 rules, because 1997 the vacancy was not there. So they have taken into consideration of this, they sought for a willingness.
This is for the subsequent
Subsequent
appointment.
appointment.
In that you referred to your recommendation
Yes.
in terms of
Yes,
the
sir.
previous. So they have not taken any objection.
Objection to that. They have accepted, they have given their willingness that we are ready to participate in the selection process, which is 2006. After this, my lord, they have given an offer of appointment. Page number 196.
Hmm. Very good. So that
But
actually
then,
open.
then, my lord, the 199.
Yes.
199, my lord. With the reference to your offer of appointment dated so and so, I do accept the terms and conditions for the above offer of appointment. with the
This
post of-
we offered, this is the subsequent.
Say
part.
subsequent appointment, they accepted it.
It knows that I admit the position of
Yes, yes,
vacancy
yes,
as.
yes. They are not.
Admission has to be specific. They
Yes,
don't
yes.
specifically admit that there is, but you can say that yes, they proceeded on the strength of this and they took the subsequent appointment. They did not protest
Yes,
by saying at least that we are disputing the position, vacancy position as
Yes.
of.
First, my lord, when they agitated is after them when they have given an appointment. That is 2016. They started agitating it. That we should be given antedated order of regular appointment instead of the 17 August 2016.
The present challenge before the tribunal was also preferred after that 2016 appointment.
Yes, ma'am.
So they waited for that
Yes.
and then.
Once they got an appointment, after that they issued a representation that is at page number 203 and which is at 6th September 2016.
All these 3 persons.
Now, this is with regard to Savila Banu.
No, all these 3 persons were appointed.
Yes, yes. Similarly, ma'am, 3 persons.
For this
17 August 2016.
So between 2015 and 2016, all these.
No agitation, no.
No, these people are given appointments during the range of 2015, 2016.
Yes, ma'am.
This period.
Yes, ma'am.
3 of them.
Yes, ma'am. But my response on the tribunal is rightly held. The tribunal is rightly held, but because once and cutoff which is given on 2000, that is 1997 vacancy, which is clearly enumerated, these are the persons. Left out these 3 persons, but as in terms of Supreme Court and commitment was done that tribunal order will be complied with, the 3 persons have to be somehow had to be accommodated. As said, they sought for their willingness that you are ready to be apply for 2001, 2006. They accepted their willingness.
Say it again.
Based on after the acceptance and offer of appointment was issued in 2016.
Because in our पूरा भी चैलेंज को जो चैलेंज था स्कोप ऑफ चैलेंज था এটা হচ্ছে সেটা তো ওখান থেকে যে কমিউনিটি দেওয়া উচিত এই যে 12 জনকে দিল ওদের 3 জনকে দিল না সেটাই ব্যাড হচ্ছে সেখান থেকে শুরু হয়েছে ওটা রিওপেন না করলে তুমি এটা দিতে পারছো ওই পয়েন্ট কিছু দিত তবেই তো রেগুলেশন প্রশ্ন আসছে এটা তো নতুন অ্যাপয়েন্টমেন্ট হয়ে গেছে This 2015-2016 is a new process of appointment altogether.
Yes, yes, Mohan, because in terms of the new rules.
So therefore, unless they get relief regarding that,
Right.
they cannot have these other reliefs also, that back wages and all everything.
Absolutely. Because that has been closed and because there is no vacancy.
So therefore, the petitioners have to succeed in their challenge to that 12-5,
Yes.
12-3 thing.
to-
Please go ahead. The challenge to reopen now for the time. And this is the
New process.
They cannot claim back wages for it. Very well. We'll continue with this tomorrow, or because we have to take up the single bench also. Mr. Sivalan, we'll hear you tomorrow, and Mr. Singh and Mr. Kumar will hear you short reply on that. Harding part, list the matter for further hearing tomorrow. Give the date tomorrow still. Thank you very much.
In the case of receiving,
Yes.
she has got all the bank details from the initial date of appointment. They had fixed the matter as level of. I'll take that.
New judgment you cannot cite in reply.
No, I'm not saying. What I'm saying, the benefit.
Mr. Seeing the difficulty we're telling you, the difficulty is that unless you succeed in your challenge to the 12 being appointed, 3 being omitted, then your entire this superstructure of back wages goes. Because this 2015-2016 is a new appointment. You have considered to that. We are not fixing you to that. Whatever you are entitled under that you get. But this cannot get you those benefits, those back wages. For that you have to succeed to
Got it, sir.
you have got it.
That matter has traveled to Supreme Court.
Then why go challenge?
I got it. They have not filed.
You should take advantage of that and file a new. We should not advise you. But this we cannot permit you. Anyway, let us come.
In case of, goes up to me, second issue is that leave regulation.
So
That I.
Now, I can could be given some precedence.
There are two part-head matters, Mr. Shamantu. We can keep it after.
Because of the lordship of director, manual listed and,
This is non-maintenance.
the law point which your lordship might learn it, you have told me that I.
This was the matter we held to be not maintainable.
Yes, yes, Lord. Short order,
That's why-
directing affidavit in opposition, they challenge it with this, that short order.
This will appear after the two part-head matters, Mr. Shamantu. Tomorrow after the two part-head.
Can be taken up.
Yes, because you'll exhaust your islander benefits after that. Manoj bhai, 13, item 13, Mr. Shamantuta, third matter হবে after these two part-head matters. Part-head গুলো উপরে দিয়ে দেবে, third owner, তারপর যেরাম serial.
Thank you.
Thank you, sir.
Blair.
বলে দিও একটা উকিল বাবু, আমরা তো
सब ले लो